I know what a good job y'all do in Orange County at the BRC on this. Having spent many months out there myself as a county judge, so I always depend on you because you do a great job.
Thank you.
Okay, so here we go. Ms. Romero, you ready?
Yes, Your Honor.
All right. Are you Jose Mundo Diaz?
Yes, sir.
Yes, sir.
Oh, wait. Now we're going to use the interpreter.
Okay.
Do you need an interpreter?
Yes, Your Honor.
Sí.
Okay, so wait till she does it in Spanish, even though you probably understand what I'm saying in English.
Está bien.
Very well.
All right. So now, as far as victims as well, Ms. Thomas, if anybody's here
No, sir.
that wants to talk, make sure,
No.
that you let me know. Okay, great. All right, sir. You're charged with battery as an incident of domestic violence. I'm going to appoint the public defender to represent you. I found probable cause for the charge. I'm going to give you a bond as follows. It's $500. You're to have no contact, direct or indirect, with the victim. You're to maintain a separate residence. You can return one time with a law enforcement officer to get any personal belongings. Do not possess or own any weapons or firearms. Do not possess or consume any alcohol or illegal drugs. Do you understand?
Sí, entiendo.
Yes, I understand.
Okay, you can take the headset off. Patricia Romero.
She bonded out, Your Honor.
All right. Nicholas Alvoy.
That's the refusal. He refused,
Is that it
Your
on
Honor.
the Spanish? Hold on.
Yes, it
Are we
is.
done with this?
Yes, Your Honor, for the Spanish, we're done.
Thanks, Ms. Romero.
You're welcome, Your Honor. Have a great weekend.
You too.
Thank you.
Nicholas
sorry,
Alvoy, he refused, Your Honor.
I'll waive the appearance, Your Honor.
All right. So, PD's waived appearance. He's charged with escape and resisting without violence. If found probable cause, the bond count one's $20,000. Count two is $250. 20. I think it's only F3 though, right? Escape, and then just 5 years for escape.
It's an F2, Judge.
I know federally it is. I don't know on
Yeah.
state level.
I'm
Your Honor,
sorry.
It's an F2.
It's an F2.
Yes, sir.
Okay. Well, there you go. All right. Jason Ford.
Refused, Your Honor.
Waive his appearance, Your Honor.
All right, so I'll appoint the PD, and he's waiving his appearance. So on the charges of possession of cocaine, attempted tampering with evidence, possession of drug paraphernalia, found probable cause. I'm modifying the bonds a little. Count one still $1,000, but I'm reducing counts 2 and 3 down to $250 each. And that is obviously a do not possess or consume any alcohol or illegal drugs. But he is out on bond in 2020 CF 3724 for possession of cocaine. I'm revoking that bond in light of the new charges.
Your Honor, can you please say that case number again?
2020 CF 3724.
Thank you.
Okay, Carissa Willis.
Yes, sir.
All right, good. Good afternoon. So, Ms. Willis, you were charged with trespass on a property after warning. I'm going to appoint the PD to represent you. I reviewed the paperwork. I found probable cause. So I'm going to keep the bond at $500 and no return to the scene. Do you understand?
Yes, sir.
All right. We have Betsy Carr up. Who do we have next?
Betsy Carr's behavior.
Okay, so we'll reset her for tomorrow. What about Steven Sears? Is he here?
Good morning, Judge. How you doing today?
I'm doing well. So, Mr. Sears, A couple things. We were supposed to see you yesterday, but there was an issue, but we got you here today.
Can we talk about, because I was confused. I went to Family's Dollar, Family General with my.
Oh, no, don't talk about the facts,
Yep.
okay? Don't talk about the facts.
Paid for it, wanted me.
I've appointed the PD to represent you, and he's sternly looking at me. Please tell him not to say anything about the case. Okay? You'll have your day in court. Today is just probable cause.
And about a
State hasn't even filed on anything yet. So that's all we're dealing with now, and we're going to deal with the bond issue as well. So let me go over this. So do you want me to waive on the first one?
Yeah,
Okay, on the first one, as requested by your counsel, I won't mention what the charges are,
Yep.
but I did find probable cause for the first charge. Now, listen, so I'm setting the bond as follows. It's $5,000, no return to the scene of the incident. You're to have
Okay.
you got to listen so I can go over this, okay? Don't argue the case. This is probable cause. I'm not your judge. Okay?
Yep.
That'll be another day. You have the right to speak right now, but everything you say is being recorded. The state's sitting here taking notes. They want to prove up their case. They'll do it through you if they have to.
Okay.
So your attorney doesn't want you to talk about the case. Okay?
Okay, sir.
All right.
One.
So the bond's $5,000, so no return to the scene, no contact, direct or indirect with the victim, and no unsupervised contact with minors during the pendency of the case. Now, am I correct that he is out on bond for a trespass in 2020 MM 2023?
Yes, sir.
Okay, I'm revoking your bond in that case in light of the new charges. Now, you got another charge, and that is the petty theft. I reviewed it. I found probable cause. I'm going to reduce the bond down to $250, but no return to the scene,
Thank you.
which is a Dollar General according to the paperwork. All right, you've got your bond. Thank you. Gabriel Riley?
Yes, sir.
All right. Oh, here we go. All right. So, counsel, you represent Mr. Riley?
I represent him on the first case, not the case he picked up today yet.
Were you talking about the possession of cocaine case?
Yes, sir. I filed no subpoena.
That's 2020 CF 1606.
I believe so, Your Honor.
What? The one he's already got a bond on?
Yes, Michael Brown on behalf of Mr. Riley, Your Honor.
Okay. But you're not here to represent him on the possession of MDMA?
For purposes of today only so far, Judge.
So, yes?
For today only, yes.
For today only. Got it. Okay. So, Mr. Riley, again, you're charged with that possession of MDMA. Is there anything you wanted to argue about probable cause?
No, for purposes of the IA, we'll stipulate probable cause, Your Honor.
Okay, because I reviewed it and I found probable cause for it. Now, the bond on this is $10,000. Did you want to talk about the bond?
Judge, I'd ask the court not to revoke the bond in the possession of cocaine case. Mr. Riley is 19 years old, has no priors besides these two cases. So I'd ask the court not to revoke his bond in the possession of cocaine. As the possession of MDMA, $10,000 is way over the bond schedule. I'd ask the court to set a reasonable bond. Mr. Riley has the support of his family. He's from here. His mother contacted me this morning. So he has a supportive family and lives locally. And, you know, he has no priors. And I'd ask the court to set a $1,000 bond as to the new law.
State, do you want to jump in?
Your Honor, I would ask that the bond is revoked on the cocaine case, the 20 CF 1606, due to the just temporal time frame between these two charges, and given that they're both drug cases, even though Mr. Riley doesn't have prior history, he obviously is starting to pick up a history.
Judge, may be heard as to the temporal issue.
Yes.
Judge, if you look at the information in 20 CF 1606, it happened in July of 2019. He was not arrested on scene. Law enforcement submitted an affidavit to the court for an arrest warrant. He was arrested in February after a July incident that Judge Carson issued a warrant on. So he's not had any scrapes since July. He was arrested on a warrant peacefully from the July possession of cocaine arrest. So the temporal issue is not as it seems off the arrest dates on its face, Your Honor.
Okay, yeah, and you can say it, you don't understand.
Just back to the temporal thing. Mr. Riley is 19 years old. He picked up the cocaine case in July, and then 8, 9, 10 months later.
And he got arrested
Except-
February 28th on it, correct?
Just the arrest warrant, Judge. No other charges.
Okay, keep going.
The state just argues that he's 19. He picked up the cocaine case in July of 2019. And then now he's picking up the ecstasy case in April of 2020. Even though it's not a years apart or anything like that, due to the defendant's age, them being still so close in time is concerning, and the state would prefer you to revoke the bond on the cocaine case.
Judge, may I respond one more time?
Yes.
I don't see a point in holding this gentleman in jail at 19 years old for simple possession charges. Given the COVID situation, he has a job, support of his family. I think reasonable bonds are reasonable here. He's never resisted. He's never possessed any weapons. He's not a danger to the community, Your Honor, and I don't see the purpose of holding him in custody on simple possession charges.
All right, here's what I'm going to do. On the new law violation, the bond will be $2,500, and I will not take action on the possession of cocaine. Now, that doesn't mean the judge who has this case may not take action, but for today, I won't. So you've got a bond. Do not possess or consume any alcohol or illegal drugs. Are we clear?
Yes, sir.
Okay.
Thank you, Your Honor. May we be excused?
Yes.
Have a good day, Judge.
You too. Okay, are we up to Esther Alexis?
Yeah, she's on the way.
No, hold on. What? Yes? Oh. Okay. All right. Are you Esther Alexis?
Yes.
All right. Well, good afternoon, ma'am. So here's what happened. You got essentially a writ of bodily attachment by the hearing officers. And what we're doing right now on these things is we're going to allow you to be released. You're going to need to show up for your hearing on June 2nd at 9:30 a.m. on that fifth floor where they do the hearing officers are, and it'll be in your paperwork. Do you think you'll be able to do that?
Yes, sir.
Okay, so we will do that, and you can go see the hearing officer on June 2nd. So they'll process you out. All right. We up to felony domestic? All right. So you're good, man.
Okay.
All right, so we're going to start with Nazar Barnes.
Good afternoon, sir.
Good afternoon, Mr. Barnes. All right, so hold on a second. Okay, so I issued a warrant for your arrest based on information provided by law enforcement
Yes.
on the charges of home invasion, domestic battery by strangulation, criminal mischief less than $1,000, and grand theft. At the time I issued the warrant, I put you essentially on a no bond basis with conditions. And today I'm going to appoint the public defender to represent you. And we're going to discuss those conditions. Again, Pete, pre-trial, let me know if anybody shows up on any of these cases, the domestic. So Count 2 was on was none. That was the domestic battery strangulation. I'm going to leave the 10,000 on count 1, and on count 2, I'm going to change that to 2,000, and then count 3 and 4 will stay the same, 1,000 and 1,000. Remember, you're not to have any direct or indirect contact with the victim. You're not to possess any weapons or firearms. You're not to return to the scene, and do not possess or consume any alcohol or illegal drugs. Are we clear?
Yes, sir.
Okay. All right, Miss Sakira Bond. Good afternoon, Ms. Bond. Is that you?
Yes.
Okay. So you were arrested for child abuse and battery as an incident of domestic violence. I'm going to appoint the PD to represent you. I read the paperwork and I did find probable cause for the charges. I'm going to set bonds as follows. Count 1 is going to be $2,000. Count 2 is going to be $1,000. So you're to have no contact, direct or indirect with the victim. You're to maintain a separate residence. And pre-trial, did y'all work up the child victim, who she's going to stay with yet? Has DCF been contacted?
Your Honor, we don't know at this moment. Because they tried to make contact with the victim, and there was no answer. They left a voicemail.
Yeah, but she's rather young. Someone needs to be out there with her.
Your Honor.
So, hello?
Your
Go ahead.
Honor. She's with her dad.
Okay, good. Thank you for answering that. So I just want to make sure she's with someone. So look, it's a maintained separate residence. So if she's not back at the Pleasant Valley address, you can return. Okay? But obviously you can't be around her and you can't contact her directly or indirectly. All right? You understand?
Yes, I understand, sir.
Okay. So do not possess any weapons or firearms. Do not possess or consume any alcohol or illegal drugs. All right, Ms. Bond?
Yes.
Okay. I have Gustavo Franco Santos.
Yes, sir.
All right, good afternoon.
Good afternoon.
You're charged with battery by strangulation as an incident of domestic violence, and then a battery of a felony nature, not a misdemeanor nature. I read the paperwork and I found probable cause. And I'm going to appoint the PD to represent you, Mr. Franco Santos. The good news is I'm going to give you a bond in this case. It's $10,000 on count 1 and $1,000 on count 2. You have to maintain separate residence, so you can have no contact, direct or indirect, with the victim. Do not possess any weapons or firearms. Do not possess or consume any alcohol or illegal drugs.
No, sir.
But I do note that, did someone say something? I do note that you have a failure to appear on a VOP arraignment for a DUI in 2018 CT 2826. It's an Osceola one. So I'm not going to touch that one, okay? Now they may revoke it in light of these new charges, but I'm not going to do it today.
Okay.
All right, so please abide by the conditions we've set. Can you do that?
Yes, sir.
All right. Well, I've got Terrell Martin. Who's this? Molly O'Shea?
Yes.
I'm sorry, what?
Molly O'Shea.
Yeah, but what happened to Terrell Martin?
Medical, Your Honor.
Medical, so reset.
Terrell,
Yes, Terrell. I'm sorry.
resets tomorrow.
Yeah. Okay, Ms. O'Shea, good afternoon.
Excuse me, Judge, it's pre-trial. She does qualify. No, she doesn't, Judge. No, she doesn't.
Okay, all right. So, Ms. O'Shea, you're charged with child abuse and batteries and incident of domestic violence. I read the paperwork, I found probable cause, and I'm going to appoint the public defender to represent you. Now, I'm going to give you a bond, but it's going to have some conditions, so listen carefully. And it'll
Your
be
Honor,
in
we
the
have a
paper.
victim.
Oh, okay.
Victim's
You have
father.
what?
Victim's
Is this
father.
Thomas O'Shea?
Yes, sir.
Okay. Are you here to talk about contact with Ellery?
Absolutely.
What is it?
Yes.
Okay. So, jail, have you confirmed that this is in fact Thomas O'Shea?
Yes, sir.
All right. Raise your right hand. We're going to swear you in.
Sir.
I'm trying the testimony shall give be the truth. Solemnly swear to tell the truth, the whole truth, and nothing but the truth.
I do.
State your name for the record.
Thomas O'Shea.
Okay. So I don't want to go into the facts of the case, and I know that y'all don't live together, and that Ellery was dropped off by Miss O'Shea's boyfriend at your house. So are you? What is it you're asking the court to do?
I'm here to understand what her potential visitation rights might be. I want to make sure that the court is protecting my daughter. I'm trying to understand what my options would be to allow her to or do not see my daughter with potential supervision. Really want to make sure we understand those details.
Okay, and that's a good point. And let me just say this, when I reviewed the paperwork, I put it on a no contact, direct or indirect. But we do have a system set up that allows for supervised visitation. Right now, there is no order for supervised visitation. It'll be something that Ms. O'Shea will eventually have to request. So right now, there's no contact, direct or indirect.
And I have no input in that, is what you're saying. I mean, I wouldn't mind if she had contact with supervision. I just want to state that. But I'll.
Okay, well,
yes.
we'll note that.
Okay.
But I'm not ordering that today because
Okay.
I need for y'all to go to the judge on this case to see what can be done, because there may be several things that have to be done. The main thing here is that y'all are living separately, so we
Yes.
don't have that issue.
Right.
So, are you guys ordering? I know in Osceola we used to order supervised visitation, but I don't know about in Orange
I've never ordered it.
from IA. Yeah, I don't think we do it here. You're going to have to do that through the judge assigned to the case. I think it's a
Okay.
Division 10 case.
Understood.
But right now there's no contact.
Okay.
And so look, Ellery's very young.
She
You
is.
can't let her text or, FaceTime or all that electronic stuff with mom while this is going on, because that would be a violation
Okay.
of the order. We're just gonna have to wait until the judge rules on what kind of visitation there can be.
Yes, sir.
All right, is there anything else you wanted to add?
Nothing at this time.
Okay, and defense, did you have any questions for Mr. Thomas O'Shea?
Oh, Your Honor.
Okay, thank you for coming. All right, so Ms. O'Shea, we're back to you.
Okay.
We're trying, sorry. Okay, there you are.
Yeah.
Okay, so, again, I've appointed the PD. I found probable cause. I'm setting the bond as follows. It's $2,000 on count one, $500 on count two. You have to maintain separate residence, which means that Ellery cannot be at your place, all right? You cannot have any contact with her, direct or indirect, until the court modifies those conditions, okay?
Okay.
So you want to get with your attorney to request that visitation. Obviously, it'd be supervised at this point, all right? Do not possess any weapons or firearms. Do not possess or consume any alcohol or illegal drugs.
Okay.
Do you understand, Ms. O'Shea?
Yes, I do.
Okay, so
Can I
you've
ask-
got your bond. Yes, ma'am.
Can I ask that he bond me out and I'll pay him back?
Yeah, sure.
Tom?
Tom, you could, Mr. O'Shea, you
I'm
can
sorry, I
bond
was-
her out.
I could, and I'm not going to do that. So you're going to have to work with your boyfriend George to get yourself
Can you
bonded out.
give me his phone number? Because I don't know his phone number.
It's
Okay,
on my
well-
cell phone. We'll take care of that. If I can get it to you, I'll get it. It's downstairs. My phone is out there.
Okay. If I could get my phone, I could transfer the money from my bank.
I know this is something that is always interesting about access to phones while at the jail.
Right.
I can't even order them to give you an aspirin. So I will let the jail follow their rules, but I understand your situation. I will ask the public defender, could you reach out to her boyfriend to post her bond?
If you could give me a number, I can.
Yeah.
And I can
So-
do that if you guys give me some time or an access to do that. I'm happy to do that.
It's on there. It's on their arrest affidavit.
His phone number? Okay, so the public defender's got the phone number. They'll reach out to the boyfriend and make a call, correct?
Okay, can I don't know if how does he pay that?
They'll figure it out.
Oh, there's a bunch of ways to pay bonds.
Okay.
They'll let them know.
Okay, Tom, can you please?
You'll see. So we're gonna get that number to the PD so they can call your boyfriend. Okay,
Your
so
Honor.
we're up to Smith Toussaint. How are you doing, sir?
I'm good, and you?
All right. So here's the situation. You got a warrant on an aggravated battery with a deadly weapon causing great bodily harm as an incident of domestic violence. It was set at a no bond basis. And with the no contact, direct or indirect with the victim, co-defendant, or witness, maintain separate residence and do not possess any weapons or firearms. Now, I don't have the affidavit on this. I have no idea. And again, I'll point to PD. Okay, do y'all pull it out? While you're doing that, he's out on bond in 2020 CF 2803. Oh, it was broken? Yeah, I do too. So, on a burglary of an occupied dwelling and a battery, but I don't know what the relationship between that case, he was arrested on February 27th of this year on that case versus the probable cause warrant. Yes, ma'am. Thank you. You get another one for doing that. Thanks. All right, let me look it over, okay?
Okay.
All right, and she's not there, correct?
Correct, Your Honor.
Okay, do we have any history other than this burglary case?
We don't have any convictions, but we have a arrest, which was a battery DV, but it was with a different victim. And then the burglary, that's it. But he don't have any convictions for Florida.
Okay, so here's what we're going to do. Just looking over this. Okay. So we're going to set the bond at $5,000 on this case. And it's going to have all the same conditions as the PC warrant did. But, and that includes, no contact, direct or indirect, with the victim, co-defendant, witness. The problem is this: it looks like, this would clearly violate your 2020 CF 2803. So I am going to revoke that bond in that case because you picked up these new charges, and you'll need to get with your attorney to schedule a bond hearing before that judge. Do you understand?
Judge, he also have an ICE hold.
Oh, okay. Hold on a second. So, you're not getting out anyway right now because I revoked your bond, but immigration has a hold that if you were eventually to get a bond, you could not get out until such time as that has worked its way through. I don't know what the deadline is these days on the ICE holds, but that has to clear before you would get out. But right now, you're not getting out anyway because I revoked your bond.
And Judge, I'm gonna ask you another question.
It's on the here. Yeah. Yes, go ahead.
Okay, for 2020 CF 002803, we didn't do anything because the offense happened before.
He was arrested on February 27th.
Correct. So you're
And
gonna
this one, oh, you're saying was before? Okay, well, thank you for pointing that out. So I'm not going to touch it.
okay.
And you can deal with it. Thank you so much, pre-trial. So no action on that, but you do have an ICE hold. So you're not getting out anyway, even with the bond, till that works its way through, okay?
I got a hold.
You got a hold. Aaron Lugo.
He qualified for pretrial release.
I should read these after I write them. I'm sorry. The clerk was bothering me. What did you say?
He qualifies for PTR.
Okay. All right. Are you Aaron Lugo?
Yes, sir.
All right, sir. So you're here because it's alleged you committed the crime of battery, incident, domestic violence towards your brother. And they're telling me that you're eligible for pretrial release. So I found probable cause. I'm appointing the public defender.
Is there a victim present for this case?
No, Your Honor.
Tyler's not there, so he's not present. So here's what we're going to do. I will order pretrial release or a $250 bond. It's your option if you for something happens. But you got to maintain a separate residence from your brother, Mr. Lugo. So you're not going to, if he's there, you can't go back home.
Okay.
You can return one time with law enforcement to get your personal belongings. You're not to have any contact with him, direct or indirect. So you can't text, email, or whatever, how people contact each other these days. Okay? And if he calls you, you can't respond because if you talk to him, you're having contact with him. So this just has to work out through the system. Do not possess any weapons or firearms, and do not possess or consume any alcohol or illegal drugs. Do you understand, Mr. Lugo?
Yes, sir.
Okay.
Judge.
Good luck.
Judge,
Yep.
can you
Yes.
ask him why he's here, which would be easier for us for pretrial? Do he consider the bond or PTR? Why he's here? Can you?
Wait, you want to work up the PTR while he's here?
Yes, sir. He qualifies, so we just want to know why he's here instead of going back trying to go and search to find him. Can you ask him why he's standing here? Which one do he prefer?
Yeah. What did you want to take advantage of the pretrial release?
What do you mean?
Have they worked up the file with you? Talked to you about it?
No.
Okay. Well, I mean, he's got the option, so y'all just talk to him afterwards. We got to keep going.
Okay.
Lamont Olasand? Did I pronounce that right?
No, sir.
How do you pronounce it?
Olasande.
Olasande. All right, sir.
He qualifies for PTR.
You're charged with battery, incident, domestic violence. Does he qualify?
Yes, he does.
Okay. So I'm going to appoint the PD to represent you. Now, is your daughter here, the victim?
No, Your Honor.
Okay, so here's what we're gonna do. It's PTR or a $250 bond. You're gonna have to maintain a separate residence, no contact, direct or indirect with the victim. Do not possess any weapons or firearms. Do not possess or consume any alcohol or illegal drugs. Do you understand?
Yes, sir.
Okay. Mario Smith?
He qualifies for PTR.
All right. Ooh. Yeah. So, Mr. Smith, how you doing today?
I'm doing good.
Great. So look, you're charged with batteries and incident of domestic violence, and I read through the paperwork.
All right.
Have you read? So I'm going to appoint the PD to represent you. I'm going to order a pretrial release as your bond condition, and now let me ask you this, pretrial. Have you been in touch with the alleged victim? Yeah.
We
Talked
called.
to her at all?
We did try to contact the victim. We didn't get an answer. We left a voicemail.
So look, I never do this, but for you, I'm going to do it, Mr. Smith, okay? Based on what I read, I'm going to put no hostile contact, okay? So that means no hostile or violent contact with the victim. But I want, before he's released, I want y'all to reach out again to the victim to let her know of this.
Okay.
I don't think the state's going to file on this, but I'm just the judge. The state makes those filing decisions, okay?
Yes, sir.
So if you choose to return to the home and she says you're being violent or hostile, like you yelled at her when she asked you to take the garbage out,
Yes, sir.
they're going to bring you back down here on a no bond status.
Oh, gosh. Okay.
So you may not want to return home, okay?
Understood.
Okay. And look, do not possess any weapons or firearms. Don't possess or consume any alcohol or illegal drugs. Just be very careful on this, okay?
Yes, sir.
I mean, I read it, and I'm not sure the state's going to be filing on this, but nonetheless, we got to take all cautions.
Yes, sir.
So don't let us all down, all right?
Will not. Will not. Thank you.
Okay. Justin Tyler.
And you, Judge, you did say just PTR, correct?
Yes, PTR straight.
Okay.
To make one more attempt to contact to let the victim know the bond conditions. All right, you Justin Tyler.
Yes, sir.
Okay. Mr. Tyler, you're charged with batteries and incident of domestic violence.
Yes, sir.
Does he qualify for PTR?
No, sir.
Okay. So I read the paperwork, found probable cause, I'm appointing the public defender. Bond's $250. You're to have no contact, direct or indirect, with the victim. Do not possess any weapons or firearms. Do not possess or consume any alcohol or illegal drugs. Now, he's out on bond in 2020 CF 3075 on an ag assault with a deadly weapon, criminal mischief, and petty theft from arrest on March 5th, 2020. Is that correct?
Correct.
Okay, so I'm revoking your bond in that case. You're going to have to go to the felony judge, in that case, Division 16, talk to your attorney to see if they will give you a bond. Do you understand?
No, I don't.
Well, I gave you a bond on the new charge, but I'm revoking the bond in your old case because you violated the conditions of your first bond by picking up new charges.
But I thought they didn't file on the other charge.
Again, you're going to need to talk
They
to
didn't
your
file
attorney
on the
on
other
that.
charge. So why am I still on bond if they didn't file on that charge?
Well, because you need to talk to your attorney. Okay? If it turns out that this one's dropped or that one's dropped, things will change, but
So
can't
I'm
answer
not
that
getting out
right
of here
now.
at all.
not today. Oh,
Sorry, Judge. PC 250, no contact.
no contact. Yeah, I said that. Weapons and weapons arms. Yeah, so they're just that. Correct. All right, is it Dayron Aguilar?
Behavior, Your Honor.
I will reset him for tomorrow. How about Antonio Cason?
He bonded.
All right, how about James Christ?
Yes, sir. Yes, Your Honor.
Oh, okay, so Mr. Chris, you're charged with the following: possession of methamphetamine and a violation of the curfew during this virus. All right, so I read the paperwork, found probable cause, going to appoint the public defender to represent you. The bond on count one's $150, count two's $1,000. But I show you're out on bond in 2020 MM 1460 on a petty theft and resisting an officer without violence. And you bonded out on that on February 22nd, 2020.
Yes, sir.
I'm revoking that bond in light of these new charges. You can go back to the county court judge to see if he or she will give you a bond. Do you understand?
Yes.
All right, Reuben Curtis. Is that you, Mr. Curtis? Yes, sir. Okay, so you're here on a possession of fentanyl and possession of drug paraphernalia. Read the paperwork, found probable cause, good on point the public defender. Count one's $1,000, count two is $100. I show in 2020 CF 2331, he's out on bond on a possession of a controlled substance and a possession of heroin in Division 19. I think Judge Roach has that division now because it was my division last year. So I'm revoking your bond in that case. You can go back to Judge Roach to see if she will give you a bond. But because you violate by picking up the new charges, I'm revoking it. Do you understand?
Yes, sir.
All right, Cassandra Davis. Is that you, Ms. Davis?
Yes, sir.
All right, well, good afternoon. You're here on a charge of aggravated battery with a deadly weapon, i.e. a golf club. And I reviewed the paperwork and I found probable cause, and I'm going to appoint the public defender to represent you. Do we have any history on Ms. Davis of import?
We have, her last conviction was 10/27/08, which was a battery. And she does have some Florida convictions. She have petty theft, battery on LEO, fleeing or eluding, theft ×2, shoplifting, trespassing, driver while license suspended ×3, possession of paraphernalia, petty theft, battery, prostitution, violation, and a couple of more batteries. Those are convictions.
Okay, so here's what I'm going to do. I'm leaving the bond at $3,500. You're not to have any contact, direct or indirect, with the victim. You're do not possess or own any weapons or firearms, and do not possess or consume any alcohol or illegal drugs. Do you understand?
Yes.
All right, Jeffrey Dempsey.
Yes, sir.
Good afternoon, Mr. Dempsey. You're charged with petty theft with 2 prior convictions. I read the paperwork. I found probable cause. I'm going to appoint the public defender to represent you. I'm going to leave the bond at $2,500 and no return to the Walgreens store in question. But I am showing in 2020 CF 4606 that you're out on bond on a petty theft with 2 priors from an arrest on March 10th of this year. In light of that, I am going to revoke your bond in that case. You can go to the Division 11 judge to see if he or she will modify that. Do you understand?
I was out on bond.
That's what it says.
Who bonded me out? I didn't even know about it.
It looks like Polikoff bail bonds bonded you out.
But I'm saying, who did it though? Who paid the bond?
It was $250.
Does it
I don't know.
It doesn't say who paid the bond?
Just the bonding agency, and it was $250 bond, which cost you $100 just to get a bond. You almost should have paid cash.
Judge, did you see the other case that he have?
Yes, Your Honor, I was about to bring that to your attention. There's another one as well.
Nope, not to my attention.
Would you like to see my arrest affidavit?
Yeah, I don't have it here, but is there another case?
Yes, sir.
20 CF 5094, the record. 5094.
No, 5094. Okay, so we were just handed it, so. All right, in that case, it's a possession of cocaine, possession of synthetic drugs, and possession of drug paraphernalia. And this is the other charge, and I don't have it for some reason. Well, let me read the affidavit, see what I think about it. It said 1,000, 150, 100. Okay, so this is 2020 CF 5094. You're charged with possession of cocaine. Again, possession of the synthetic drug and possession of drug paraphernalia. And I found probable cause. I'll appoint the public defender for you that in that case as well. And I'll leave the bonds at 1,000, 150, and 100. All right, so I think that takes care of all his cases. All right, Jerry, is it Dorsimi? How do you pronounce your name, sir? Dorisme. Thank you. Okay, I'm going to point to PD. PD, did you want me to waive the reading? PD? Thompson, do you want me to waive the reading?
Yes, Your Honor.
Okay, so I read the paperwork and I did find probable cause. And I'm setting the bond as follows. Count 1, $10,000. Count 2, $3,000. And count 3, $2,000. You're maintain separate residence. So you can return one time with law enforcement to get your personal belongings. You're to have no contact, direct or indirect, with the victim. You're to have no unsupervised contact with any minors during the pendency of this case. Do not possess any weapons or firearms, and do not possess or consume any alcohol or illegal drugs. Do you understand, Mr. Dorisme?
Yes, Your Honor.
All right. Is this me? Okay. All right. Are we up to Amanda? Is it easy for?
Yes, Your Honor.
Did I pronounce it right?
Yes.
Okay. So you're here on charge of possession of THC and the possession of cannabis less than 20 grams. I read the paperwork and found probable cause. We're going to keep the bonds at 2,000 on count 1 and 200 on count 2. I don't know if you're planning going back to North Dakota after you get out, but make sure that you appear in these cases.
I actually live in Broward County.
Okay. Well, they're still showing you in North Dakota.
I couldn't
So,
change my license
Yeah.
over yet because of the COVID. It was shut down, so that's why.
I hear you on that.
Your Honor, would you have any objections to an ROR in this case? Depending on her criminal history, for count 1, she would probably qualify for a diversion program, and I don't
Level 2.
Yeah, I don't anticipate the state filing on count 2, Your Honor.
State, did you
I'm
want
not
to
sure of
jump
her
in?
history, though.
I am unsure about her history. Definitely.
Yeah. What do you show pre-trial?
For her history, we have A last out-of-state conviction was 2/21/2017, which was larceny of merchandise. No Florida convictions, but she had the arrest, which was trespass and structure. And she has more out-of-state convictions. If you want me to read them up.
Well, I just don't know if she's going to qualify or not.
I would ask that we leave it as it is, Your Honor.
Okay, what I'll do is this. I'll take you at your word that you're living down in Broward. Well, no, I won't. Where do you live in Broward?
3307 Port Royal Drive South, apartment 709.
What town is that?
It's Fort Lauderdale, 33308.
What's the first city north of Fort Lauderdale driving on I-95?
Pompano.
I'll take that. All right, so I'm going to lower your bond. I was going to ask you what the state bird is, but I wouldn't do that to you. So I am going to lower your bond down to $500 on count 1 and $100 on count 2. Do not possess or consume any alcohol or illegal drugs.
Okay,
So you have your bond.
thank you.
Huh? Yeah.
Was the PD appointed on this, Your Honor?
Yes, PD was appointed. All right, so we're dealing with Jeremino Hall. Is that you, Mr. Hall?
Yes, sir.
All right, I got 3 things I got to deal with, all right? Let's start with the first one. You're charged with grand theft, 3rd degree of a motor vehicle, fleeing or attempting to elude a law enforcement officer with the lights and sirens engaged, and resisting an officer without violence. I'm going to appoint the PD on all of these cases. Then in a separate charge, they charged you with driving a license revoked as a habitual traffic offender. And then the 3rd case was burglary of an occupied dwelling. So I reviewed all the paperwork and I did find probable cause for all the charges. I am going to give you a bond on that fleeing and eluding. That's the one you didn't have a bond on. So as to the grand theft, fleeing, eluding, and resisting without violence, the bonds are $1,000, $5,000, and $500.
All right, sir.
Then hold on, and then on the Dwellis HTL, we'll keep it at $2,500, and then the burglary of an occupied dwelling, we will keep at $5,000. No return to the scene, no contact with the victim. Yes, did you want to say something? Don't talk about the facts of the case.
Okay, but you say it's on the paper right there. You see it. The people told me I could stay there. You know what I'm saying? Like during the code
Yeah, I
and
know,
stuff
but
like
you
that.
don't talk about the facts because the prosecutor's here. She's taking notes.
And then
But I've appointed the PD in all 3 cases. You'll just need to talk to PD. But the main thing is you've got a bond.
All right, and then the other thing I want to bring up: how can I get charged with resisting of arrest without violence? You got to have violence when you're doing resist.
Well, how? Well, your case is a good example of how one can get charged and arrested for it. But other than that, talk to your attorney,
All right.
Robert Helsill.
He qualifies for PTR.
Okay.
Yes, sir.
Did I pronounce that right?
Helsel.
Helsill. All right. So you're charged with aggravated assault with a firearm. And yes, it did turn out to be a BB gun later on, but I found probable cause for the charges. So here's what I'm going to do. I will give you pretrial release, but if you want to pay a bond, so it's it'd be $3,000. Now, do not possess or own any weapons or firearms, and that includes a BB gun. Surrender any such weapons or firearms to the Orange County Sheriff's Office within 24 hours of your release. You're to have no contact with the victim, direct or indirect. So I know that y'all are in the same neighborhood. So at this point, don't look over to them. And while you may have to drive by there, don't look toward them when you drive by. Okay? So you have to be very careful when you're in the same neighborhood situation. All right? Huh? PTR 3,000. Okay. Seneca Howard.
Yes,
sir.
Okay, Mr. Howard, there was a probable cause capias issued on a vehicular homicide, leaving the scene of a crash with death and driving while license suspended or revoked. With a serious bodily injury or death. And the bonds are set at the 25,000, 10,000, and 5,000. Now, he's got that other case that he was arrested on back in December of 2019, the 2019 CF 17381, the grand theft third degree of a motor vehicle. Do you know what the date is on the warrant for those charges?
It's 20 charges, sir.
Yeah, hold on, I'm gonna see if the state knows.
Date of the warrant?
Well, the date of the incident. And while she's looking that up, the same conditions apply that are on the CAPIA, so no contact directly or indirectly with the victim, co-defendant, or witness. Do not return to the scene of the offense and do not drive without a valid driver's license.
Yes, sir.
So hold on, we're gonna see.
If I have any holes.
Yeah.
For the 19 CF 17381 case, I have a date of incident as December 23rd, 2019.
Okay, so the date he was arrested. What about the PC warrant? That was issued on April 7th. But do you know the dates?
It's not on our case management program, but I'll pull up the website real quick.
What do you show?
See it?
Well, from the PC warrant, what's the date of the incident? Okay, so it's in December of 2019. Oh, it's like this. Essentially, the same date. So I'm not going to revoke his bond in that case. The 2019 CO. I think it's arising on the same incident. So you've got your bond. You've got your conditions of your bond.
And so
And I'm adding also, do not drive without a valid driver's license.
yes, sir.
Okay.
Do I have any holes on me?
No, do y'all?
Because they
That,
saying
that one is I took off because it looks like it's the same incident.
All right, I appreciate you.
I'm not
Thanks,
going to revoke that bond. Doesn't mean the judge in the division may not do it, but I'm not going to do it.
sir. All right, thanks, sir.
Mark Jarrell.
Yes, sir.
All right, I got two things for you. First of all, there's a charge of possession of cocaine. Reviewed the paperwork, found probable cause. Point to PD. Bonds $1,000. Don't possess or consume any alcohol or illegal drugs. But you also picked up a driving while license revoked with 2 prior convictions. I found probable cause for that. I'm going to increase the bond to $5,000 on that, and do not drive without a valid driver's license or automobile insurance. All right, so you have bonds in both cases, and I've appointed the PT in both cases. Do you understand?
Thank you.
All right.
Your Honor, in regards to the possession of cocaine case, you just said the condition was no drugs or alcohol?
Don't possess, yeah. Uh-huh.
Thank you.
All right, we got Ms. Jones. Okay, so it's Unica Jones.
Yes.
Okay, ma'am. Good afternoon. I've got a couple matters to cover with you. First, there's a burglary of an occupied dwelling. And I reviewed the paperwork on this and I found probable cause for the charges, and I'm going to keep the bond at $5,000, no return to the scene. Do not contact, direct or indirect, the victims in this case. And then you also have a trespass and a conveyance and resisting officer without violence. I found probable cause for that as well. I will keep the bonds at 100 and 500. Again, do not return to the scene and no contact with the victims. And so you have the PD in both cases. Do you understand?
No.
You don't? Okay, well, they'll have paperwork for you. Is there a specific question you got? Because I don't want to talk about the facts of the case.
Can you just repeat what you just said on the last part?
Well, you've got the bonds of 100 and 500 on the trespass and resisting without violence, and the no return to the scene, and no contact with the victims, direct or indirect. And then the burglary was I kept the bond at 5,000 with that no return, no contact. So essentially the same bonds you had before you saw me.
Okay.
Okay. Charles Nelson.
His behavior, Your Honor.
All right, we'll reset him. How about Carlos Pagan? Good afternoon, Mr. Pagan.
Good afternoon.
All right, sir. So you've got two matters I've got to deal with. The first one's the possession of fentanyl, possession of heroin, and possession of drug paraphernalia. I reviewed the paperwork, found probable cause, and I'm appointing the PD to represent you. I'm staying the bonds at 1,000, 150, 100. Do not possess or consume any alcohol or illegal drugs. The second case is the carrying a concealed weapon by a convicted felon. I found probable cause for that as well. Point the PD, and we'll keep the bond at $1,000. Do not possess or own any weapons or firearms. Do you understand, Mr. Pagan?
Yes, sir.
All right, Carlos Rivera.
He refused, Your Honor.
All right, we'll reset him.
I waive his appearance, Your Honor.
Well, I'm going to revoke his bond. You want him to see the judge?
If you're gonna revoke it, I mean, it doesn't really matter anyway. I'll just go ahead and waive his appearance.
Okay, so point the PD, and there, the PD has waived his appearance on this. So I'm finding probable cause on all the charges: trafficking heroin greater than 4 but less than 14 grams, staying the bond at 100,000. Possession of heroin with intent to sell or deliver, staying the bond at 150. Possession of alprazolam with intent to sell, staying the bond at 150. Possession of cocaine with intent to sell or deliver, stay the bond at 150. Possession of drug paraphernalia, stay the bond at 100. And then trespass on property after warning, again, staying at 100, no return to the scene. And then in case number 2019 CF 12982, I'm revoking his bond in that drug case. And again, point the PD on that as well. Now, he got out on that one. It shows both the surety bond and the 33-day motion. So I don't know which is which. State, can you look real quick on that?
Can I have the case number again, Your Honor?
Yeah, 2019 CF 12982. Did they ever file on that?
Yes, Your Honor.
Does he have a bond or is he ROR? But they filed, right?
They filed
All right.
possession of heroin, possession
So
of
I'm revoking his bond. Okay, so we're up to Terry Robinson. Is that you, Mr. Robinson?
Yes, sir.
Okay. So in this case, I'm going to appoint the public defender. We have 3 cases to cover with you. All right, the first one is, hold on a second. Okay, you're right. Hold on. No? Look at this. I got 3. No. I got 3. It says 1 of 2, but I see a third. Same.
Docket number 901268, 01271, 01280. Okay, yep. Date of birth. Ash Creek Route. They have.
Pre-trial, you got 3 cases for him? It looks
Yes,
like an add-on.
Yes, sir. We have 3 cases.
Okay. All right, so here we go. So, Mr. Robinson, I'm just going to go through these. You were charged with trafficking cocaine greater than 28 but less than 200 grams. Found probable cause, and I'm staying the bond at $50,000. Do not possess or consume any alcohol or illegal drugs. Next case is possession of fentanyl and possession of cocaine. Found probable cause, point the public defender. Staying the bonds at $1,150. Do not possess or consume any alcohol or illegal drugs. Then there was the add-on charge of trafficking in fentanyl, 4 grams or more, possession of cocaine with intent to sell or deliver, possession of fentanyl, possession of cocaine, possession of drug paraphernalia, and possession of cannabis less than 20 grams. Again, point the PD, found probable cause. I'm going to stay the bonds at $200,000 on count 1, and then 150, 150, 150, and then count 4. The paraphernalia is 100, and the cannabis less than 20 grams is 100. Do not possess or consume any alcohol or illegal drugs. And you can get with your public defender to schedule a bond reduction hearing if you so like. Do you understand?
Yes.
Okay. All right, we up to Brian Scott. Is that you, Mr. Scott?
Yes, sir.
Okay, so here's what we got. I got a warrant, and it was written threats to kill or do bodily harm in violation of pretrial release condition on a domestic violence case. So I set it at a none till you're seen at IAs, and I had the no contact with the victim and do not possess or own any weapons or firearms. So at this point, we're going to talk about a bond on that, but I will note that you are out on bond in 2020 MM 3011 on a battery as an incident of domestic violence, and I'm going to revoke the bond in that case in light of you picking up these new charges. So now we're going to talk about the bond and the written threats to kill or do bodily harm in the violation. So I'm setting it on count 1 at $15,000, and then on count 2, it will be $1,000. You can comply with all existing court injunctions and conditions of your pretrial release, which I'm now revoking. So no contact with the victim, direct or indirect. Don't possess or own any weapons or firearms. Do not possess or consume any alcohol or illegal drugs. Do you understand, sir?
Sir, I don't really understand. So
I gave you a bond. You didn't have a bond on the warrant. I just gave you a bond on it.
Okay.
But I'm revoking your bond on the battery case that you have because you picked up these new charges. So you'll have to go back to the county court judge on that dating violence battery injunction to see if he or she will give you a bond, and you have a bond now on the felony charges.
So am I able to get out on these bonds?
Huh?
Am I able to get out if I bond out today?
Not today, because I revoked your bond in your other case because you picked up the new charges. You'll have to have a hearing on that. But I did give you a bond on the new charges.
Okay.
I did not.
I'm sorry, what was that bond?
Melanie Soto.
Hello.
All right, is that you, Ms. Soto?
Yes, sir.
Okay, so you're here on a possession of fentanyl, tampering with physical evidence, possession of drug paraphernalia, and resisting officer without violence. I'm going to appoint the public defender to represent you. I found probable cause for the charges. I'm going to keep the bonds as they are. 1,000, 150, 100, 100. Do not possess or consume any alcohol or illegal drugs. But I show that you are out on a bond in 2020 MM 2676 which is a battery or resisting officer without violence. I am going to revoke that bond in light of the new charges. Again, point to PD and you can schedule a hearing on that. You understand?
No, I do not.
Okay, I stayed the bonds on your new charges, but because you were out on bond at the time of picking up these new charges, I'm revoking your bond in the older case because that's a violation of your conditions on your bond. So you'll have to go back to that judge to see if he or she will put a bond back on it.
Okay.
All right, Isaac Veloso,
Yes, Your Honor.
did I say that right?
Yes, Your Honor.
Okay. You're here on a burglary of a structure and petty theft charges.
Yes, sir.
I'm going to appoint the public defender to represent you. I'm going to find that there's probable cause. I'm going to keep the bonds as they are, $3,500 on count 1 and $250 on count 2. No return to the scene, no contact with the victim.
Your Honor, would you have any objection to reducing count 1 to $1,000? Reading the arrest affidavit, just strictly from the arrest affidavit, there was a personal admission that's saying that he was just eating food because he was hungry, and it looks like the place was closed down, so he used this place as shelter. Your Honor, he may have some defenses there to the charge of burglary, which is going to be a trial issue, but because of the facts, Your Honor, I would ask for a lower bond in this case, Your Honor. Not necessarily a probable cause challenge.
You don't understand. You're good.
Have it. Your Honor, there's probable cause for the burglary of a structure. And the bond, I believe, is reasonable given the nature of the offense and the nature that he also picked up a petty theft at the same time. He wasn't just sitting there eating food. He also committed another offense during the burglary of a structure.
Okay, I'm going to leave it as is, but thanks for asking. All right, so you can go to your judge if you want to try to modify that. Okay, so we're up to Nathaniel Wesley. Is that you, sir?
Yes, sir.
All right, so here's what we got. You're charged with burglary of an occupied structure during a state of emergency, resisting officer without violence, and providing false ID to a law enforcement officer. I'm going to appoint the PD to represent you. And I reviewed the paperwork. I found probable cause for the charges. And I'm going to set the bond at $3,500 on count 1, $100 on count 2, and $100 on count 3. Now, I show you're out on bond on 3 different cases. A possession of cocaine in 2020 CF 4233. A grand theft 3rd degree of a motor vehicle in 2020 CF 4234. And then grand theft 3rd degree of a motor vehicle 2020 CF 4232. In light of your new charges, I'm revoking your bonds on those 3 other cases and appoint the PD, and you can, again, schedule a bond hearing. Do you understand?
Yes, sir.
We have another.
All right, and then hold on, don't go yet. You also have some felony traffic cases as well. And they are grand theft, 3rd degree of a motor vehicle, fleeing or attempting to elude a police officer, and larceny, 5,000 to less than 10,000 during a state of emergency. I'm going to appoint the public defender to represent you on these charges as well. And I found probable cause, so I'm going to give you a bond on the count 1. It'll be $2,500. Count 2 will be $2,500, and count 3 will be $1,000. No contact with the victim. And again, I revoked your bond in those other cases, so you'll have to deal with those as well. All right, Willie Wright. Right, we've got 2 matters for him, is that correct?
Correct.
Okay. So, Mr. Wright, good afternoon. How are you?
How are you, Your Honor?
I'm doing well. Thank you for asking. So here, let me cover this with you. So you picked up a driving while license permanently revoked. I'm going to point the PD and found probable cause for that. I'll leave the bond at $5,000 and do not drive without a valid driver's license. Then you've got the grand theft, 3rd degree of a motor vehicle, found probable cause, point to PD. I'll keep that at $1,000 as well. And then I show that he is out on bond on a possession of a controlled substance in 2019, CF 16419. I'm going to revoke that bond in light of these new charges. Again, point to PD, and you can schedule a time with them, with the judge.
Excuse me, sorry. So I have to, so I can't bond out?
No, sir, you got to go back to the Division 16 on that possession controlled substance, see if the judge will give you a bond.
Your Honor, I can barely afford these bonds, Your Honor. It's like, and I have no failure to appear or anything like that, Your Honor. So I'm trying, like.
Sure, I understand, but you'll need to talk to the judge assigned to the division. They'll have to make that decision. All right, Manuel Santiago. Is that you, Mr. Santiago?
Yes, it is, Your Honor.
Okay, so you picked up a charge for a petty theft, and I reviewed the paperwork and found probable cause, appoint the PD. I'll leave the bond at $500 and no return to the Lowe's store in question.
Okay, Your Honor.
But that was the good news. The bad news is that in 2019 CF 17176, you're charged with petty theft with 2 priors and using an anti-shoplifting control device. I'm revoking your bond in that case. You'll need to go back to Division 15 to see if the judge will give you a bond. Do you understand?
Yes, Your Honor.
All right. Are we up to traffic?
Yes, sir.
All right, start yelling out the ones that, as I go through, if they bonded out.
Okay.
All right, Damian Cheney.
Yes, sir.
All right, how are you doing today, Ms. Cheney?
I'm good. How are you?
Good. So let me go over this with you. You picked up a driving license suspended or revoked. Reviewed the paperwork, found probable cause, point to PD. It's a $500 bond. Is there some reason you haven't bonded out yet?
Well, I was told by the officer that he was just gonna give me a ticket. But I guess because I'm considered homeless, that he had to arrest me.
Besides that, let me ask you: is there a reason you haven't posted the $500 bond?
Well, to be honest with you, I mean, I don't really have anybody that'll post it for me.
Right. Do you have any family or anybody that could post it for you?
No, sir. And the officer told me that I guess I would supposedly be RR'd, but I don't, know how that works.
All right. Well, look, I'm going to leave it as is.
Your Honor, can I make an argument for an ROR?
Listen.
Depending on his history, of course, I don't have it before me, but when this case is transferred downtown with the client being homeless, if he's able to get a driver's license, it'll probably be no prost or reduced to a lower offense. With him being homeless, he may not be able to get a license because of the monetary issue. The PD that's going to be in the misdemeanor court could probably negotiate a failure to display and probably a credit time served offer, Your Honor. I would just ask for him to be ROR in this scenario.
I think you're probably right. You can send me an email when it happens, but today
It's not the issue we have.
I'm not going to do it. Huh?
That's not the issue we have before the court.
Yeah. But you're probably right. That may happen. But today he's got a bond, so he can bond out. I just, sometimes on these traffics, you wonder why people are still here. So, all right, sir. All right, we up to pleables? Is that correct?
Yes, Your Honor.
Okay, so Jean Antoine.
Gene Antoine is medical, Your Honor.
Okay, we'll reset that tomorrow if he's available. Is it Ennis?
Yes, sir.
All right, step on up. Okay, Mr. Ennis, you're charged with possession of drug paraphernalia. And I found probable cause. Now, is the state making offers on drug paraphernalia at IAs?
At IA, it's complicated just because usually for a drug paraphernalia, you do like a level 1 drug diversion.
So this is the onerous 4-hour online class or 2-hour class with 4 hours of. No.
The level 1 drug diversion we're doing for possession of cannabis under 20 or possession of paraphernalia, and they literally watch like a 39-minute long video.
Oh, that's level 2 I was talking
Yes.
about. Okay.
That's so. I mean, obviously he can't watch the video right now. So I mean,
So what are y'all doing at IAs?
Your Honor, when I was down at the BRC, I just left there a couple of months, well, maybe almost a year ago. But when it came to possession of marijuana or drug paraphernalia, we were ROR in these cases, Your Honor.
Yeah. His problem is he's got the trespass structure
Okay.
that he has outstanding. So that's the problem, I guess.
I'm pulling history real fast to see if he wants to take a potential withhold or something. If you give me a second,
You're not out on
see.
Probation on anything, are you?
No, sir.
Okay.
I live in a shelter.
Judge, this is pretrial. Did you see that he have one case that he's out on bond on?
Yeah, the trespass and the structure.
And he has another case that we updated that he's also was pending active pretrial diversion for a possession of drug paraphernalia. That case number is 2019-006517.
MM 2019-MM6517. It was an Orange County case. It was a paraphernalia he did PTD on.
We don't have that. Well, you do this. Don't touch that one. We're not gonna take no action, but I tell you what.
If he wants to plead today, all I'm seeing is driving offenses, dwellis offenses, felony driving offenses,
So what would be the offer?
withhold 1 day credit time served, court costs. Withhold 1 day credit time served and court costs.
Okay. You want to talk to the PD? Is that something you're interested in doing? Because, I mean, I'm not telling you what'll happen if you don't take it, but there are 2 cases that you're out on bond. So you want to do a withhold, credit time served, and court cost on the drug paraphernalia, and I don't touch the bonds in the other cases, or do you want to bond on this one and see what I do?
I take the withhold.
Okay, so we're not having them fill out their rights, right, at the jail. What happened? When did that stop? Because when I was out there, we did.
Since it's COVID-19, we don't have a PD in there to sign.
Oh, that's true.
I was supposed to be down there.
Get a Tyvek suit, a respirator, and get down there.
I know, right?
You're gonna let this stop you from you doing your work? So look, we don't have a plea form to give you, but we're gonna swear you in. Go ahead. You want to swear him in?
Oh, I'm sorry. Swear affirm the testimony shall give me the truth, the whole truth, and nothing but the truth.
Did you hear that?
No, sir.
Okay.
Swear and affirm the testimony you should give me the truth, the whole truth, and nothing but the truth.
Yes, ma'am. Sorry.
Okay, so great. So here's what we're gonna do. So you're charged with possession of drug paraphernalia. What happened to PD? I was gonna have him stipulate to a factual basis.
I'll give one.
Just see if he'll. Okay, so here's what's gonna happen. The state is offered to do a withhold of adjudication, credit time served, and court costs. if you agree to plea essentially no contest to the charge. Now, you have lots of constitutional rights, and those rights include the right to a trial by jury pursuant to the Sixth Amendment to the Constitution, a presumption of innocence at trial, and the state would have had the burden of proving this case beyond and to the exclusion of every reasonable doubt. You would have been able to see and hear and have your attorney cross-examine any witnesses that the state were to call in the case against you, and you could testify if you so desire. But if you choose not to testify, I or the judge would instruct the jury not to punish you in any way for electing to exercise your constitutional right to remain silent. If you enter this plea, you're essentially waiving any objections to the charges and any kind of appeal, except, of course, to the legality of the sentence and the jurisdiction of the court. So do you understand these rights that I'm referring to?
Yes, sir. Yes, Honor.
Okay. And are you entering a plea to this charge freely and voluntarily? Are you doing this freely and voluntarily, or are you in any way being coerced, threatened, or forced?
No, voluntarily.
Okay. So as to the charge of possession of drug paraphernalia, it's a first-degree misdemeanor. Oh, are you waiving any defects?
Yes, for the purpose of the plea, Your Honor.
Okay.
We'll enter a plea of no contest.
All right. So as to the charge, do you plead no contest to the charge?
Yes, Your Honor.
Okay. So I'm going to accept your plea, find that it was freely and voluntarily given, and that you understood your rights. Are you under the influence of any pills, drugs, or alcoholic beverages?
No, sir.
And that you're fully cognizant. So I'm going to withhold adjudication. I'm going to sentence you to time served. And now we've got some court costs, and they total $273. I'm going to have you report to the clerk's office within 6 months of your release to work out a payment plan. You understand?
6 months?
Well, I'm giving you 6 months so that we can get through the virus and you can get back to work. Okay?
6 months.
I said you don't have to go to the clerk until 6 months. You can go tomorrow.
Okay. All right.
You want, but
Yes, sir.
no later than 6 months from your release. Okay?
Yes, sir.
All right. You got 30 days to appeal my decision. And those appeals got to be in writing, filed with the clerk. The can't afford attorney won't be appointed. Oh, okay. So I'm not taking any action on your other cases then. So they should be processing you out.
Thank you.
Good luck, sir. Is Luke Laurent there?
Yes, sir.
How are you doing?
Doing good.
All right. So you're charged with trespass.
Yes.
And I'm going to find probable cause for the charge. Now, the bond would have been $500 and no return to the scene. You want to see if the state has an offer on this?
Talking to me? Excuse me?
State, you got an offer for Mr. Laurent?
Talking to me?
Yeah. Can you see me?
Yes, Your Honor, we can see you.
Okay. So let's see what the offer would be. Now, whatever we do, you cannot return to that gas and go station. Do you understand?
Yes, sir.
You just stay away from there.
Yes, sir. I was just crossing the street trying to walk away.
I hear you, but just stay away from don't cross the street where gas and go is.
All right.
Don't get on their property.
Thank you.
Your Honor, after looking at his history, the state's offer would be a withhold, no return to the gas and go, located at 6415 West Colonial Drive, and no contact with Mr. Shiraz.
Okay, so you can't contact Mr. Shiraz. You can't return to the gas and go.
Okay.
Is that what you want to do?
Yes.
Okay, we're going to swear you in.
Raise your right hand.
Yes, sir.
You solemnly swear to testify. You shall give this just nothing. Okay, do you solemnly swear that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
State your full name.
Luke Laurent.
All right, sir. So, it's my understanding you want to plead no contest to this charge of trespass. In exchange, you'd be a withhold of adjudication, credit for time served, no contact with Shiraz Plumber, and no return to the Gas and Go. Plus court costs. Is that what you want to do?
Yes.
All right. Now, you understand that you have valuable constitutional rights. You could, for example, we could have a jury trial in this case. You'd be presumed innocent, and the jury would be instructed to that effect. You don't have to testify, but you can testify if you want to. You can cross-examine state witnesses, and of course, you got a right to appeal the case. But if you take this plea, you're essentially waiving that right, except to if the sentence was illegal or I didn't have jurisdiction to do it. You understand all those rights?
Yes.
Are you currently under the influence of any pills, drugs, or alcoholic beverages?
Not right now. Just alcohol, but not right now.
Okay. So does that mean when you leave, you will be, or you were at some point before today?
Some point before today.
All right. So here's the thing. You got arrested at, let me pull this up, at, what was that, 7:12
Yes, I think
p.m. yesterday, and it's 1:30 today. So do you feel that you understand what's going on?
Yes, therefore.
You haven't had any alcohol at the jail, have you?
No.
Okay. If I ask you who the President of the United States is, what would you say?
Excuse me?
Who's the President of the United States?
Oh, Bush? Not Bush.
Who? Hey, no help from the audience, okay?
Oh, they not. That's it.
Who?
God didn't name my, so I might have tape at the time. God didn't name.
I still can't hear you. Do you know who the president is?
No.
If you don't, that's okay. Do you know who the governor is?
No, sir.
Do you know the square root of pi?
No. Square.
Okay, I was just curious. I was working my way through. All right, so let me ask you this. What's your date of birth?
9675.
Okay. And do you feel you understand what's going on?
Yes.
All right. Well, I do too, because I've had an opportunity to observe you and hear you. And although you may not keep up with the current politics, I think you do. You are alert and oriented. Okay, so as to the charge of trespass, how do you plead? No contest? Guilty or not guilty?
No contest.
All right, I'll accept your plea. Sentence you as previously indicated. Withhold. Time served. Court costs $273. Report to the clerk's office within 6 months of your release to work out a payment plan. No contact with Shiraz Plumber and no return to the Gas and Go. All right?
Yeah.
And you got 30 days to appeal my decision as well.
All right, thank you.
Good luck. All right, Ms. Manco, I hope you know who the president is.
Yes, sir, I do.
Okay, so listen. We got good news and not so good news. You ready? All right. You got charged with possession of drug paraphernalia, resisting officer without violence, and littering.
Yeah.
And, okay, I reviewed the paperwork, and I found probable cause for the charges. So you have a bond on these that was 500, 100, 100, but we're going to see if the state wants to make an offer on it. The reason I say that is because you're out on a possession of cocaine, tampering with physical evidence, and possession of drug paraphernalia in 2020 CF 492 0. And I would be revoking your bond in that case potentially, because of the new charges. So State, do you have an offer? Are you out on probation on anything?
No?
Okay.
Can you verify the spelling of her first name? I believe it may be incorrect.
Is it Fleicia?
Felicia.
So are you saying there's an extra I in there when I did it?
No. It's just the L and the E are swapped.
Okay, so spell your first name again, Miss Banco.
Felicia.
So it's Felicia, and the jail has you down with a FLE. So, jail, have you confirmed her identity?
Yes, sir.
So is it Felicia FLE or Felicia FEL, or is it a common name that she uses? Y'all know the tater salad story? Yeah. From the comedian. Guy raised, they asked him his name, he says tater salad. So in his arrest records, AKA.
Ron White?
Yes, tater salad. Okay. I thought it was.
I wouldn't say, because I respond.
Hold on, we're looking.
Is it the cocaine, tampering with physical evidence, and the possession of drug paraphernalia? Was that the case that she picked up 4 days before this one?
Okay, you say so. April 21st, yeah.
Yeah. She has a prior possession of drug paraphernalia, so it would be an adjudication on the drug paraphernalia. A withhold on the littering. And I don't see any prior history regarding resisting an officer without violence. And due to the nature of the stop on this one, she was just walking across the road diagonally, a withhold as well. So a adjudication on.
Time served?
Yes, Your Honor.
Okay, so here it is, Miss Felicia Banco. The state's offering you the following. On the first charge, possession of drug paraphernalia, you'd be adjudicated guilty of that charge and time served plus court costs. Count two, the resisting without violence would be a withhold, time served. This is all concurrent, okay, all together. And then the littering would be a withhold as well.
Okay. Time served?
Time served
Okay.
and your court costs.
I can go home today.
That's the goal.
Okay, I was just making sure.
But I can't make a promise about anything in life. But you should. How about that?
Okay, that's
But they got to process you.
That's fine.
I'm taking no action on that one. So we're going to swear you in. Can't wait.
Raise your right hand. You solemnly swear that the testimony you shall give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
All right. State your full name.
Felicia Marie Manco.
Okay, Ms. Banco. As you know, you have the 3 charges for which you want to take a plea. I'm going to take no action on your outstanding bond. I'm not going to touch it. So that hold would be released. You understand that you have valuable constitutional rights. You could go to trial. You could have an attorney. You can testify, you can remain silent. And you're waiving all those rights if you take this plea. Do you understand that?
Yes, sir.
All right. Are you currently under the influence of any pills, drugs, or alcoholic beverages?
No.
All right. And who's the president of the United States?
Donald Trump.
All right. Now, as to the charge of possession of drug paraphernalia, how do you plead? No contest, guilty, or not guilty?
No contest.
Count 2, resisting an officer without violence.
Not guilty.
Well, if you do not guilty, then we have to have you go forward on
You
the
plead
case.
no contest.
If you plead no contest, you can take a plea. Okay, good. You were testing me, weren't you? Did I pass?
You did.
Okay. Littering. How do you want to plead to that?
It's due to the situation. He told me not to leave the front of his truck. So the only thing I could do is put the cigarette. So guilty?
Well, you want to change that to a no
Yeah,
contest?
we do no contest.
Okay.
Because I'm actually going
I'm
to the
gonna-
courthouse on Monday, if I can, if it's open, to file a suit against those officers anyway. So
Okay. Not going to touch that one. I'm moving on to the case now. So I'm going to accept your plea, find that you are alert and oriented, that you understood your rights and you waived them. And I'm going to sentence you as indicated. Possession of drug paraphernalia and adjudicate you guilty, time served, and court costs, resisting officer without violence, withhold on the littering. So your court costs total $273. So you have 6 months from your release to report to the clerk's office to work out a payment plan on those. Do you understand?
yes, sir.
You got 30 days to appeal my decision. This appeal's got to be in writing filed with the clerk's office. Okay. Good luck, Ms. Monica.
Thank you, guys.
All right. Do I have Anthony Tibbet here?
Yes, sir, Mr. Tebow.
Tebow, thank you. Well, that's a name I like, Tebow. Like the best quarterback ever. Wait a second, I gotta hold the state in contempt for that last comment. We'll get back to yours in an hour. All right, now look, Mr. Tebow, here's the situation. You got picked up on a possession of cannabis less than 20 grams, and I found probable cause of the charges.
On the way home from work, sir.
Oh, don't talk about the facts of the case.
I'm sorry.
So look, you made whatever defenses you have, that's fine. Here's the situation. If you want to take an offer on the case, the state would make the following offer.
Your Honor, depending on his criminal history, he'll probably qualify for free-child diversion, but less than 20 grams.
Probably will, but he's out on bond on trafficking and possession of firearm by a convicted felon, possession of drug paraphernalia, and possession of cannabis less than 20 grams.
Okay.
That he went out on bond on March 6th. So you're probably right.
For him to qualify for pre-trial diversion, he would have to bond. Due to his history, it would be an adjudication of court costs, Your Honor.
All right, so if you were to take the offer to be adjudication of guilt, now would there be a suspension of driving privileges as a result of that adjudication?
6 months.
6 month suspension, although there is a process. Huh?
1 year.
Well, I think they changed it.
6 months.
They changed it down to 6 months, so like a year ago or something. And there's a way to get out of that 6 month suspension. There's a process under the new statute, but it would be a 6 month suspension of driving privileges as well. You're not on probation, are you?
No, sir.
Okay. And court costs. So do you want time served, did you want to take that offer, or would you like to keep the bond? And then me address your case that you're out on bond?
No, well, only thing, sir, I just want to put on file, like, I'm the only one working with this coronavirus, and I'm a machine operator with my job. So will I still be able to run my machine if y'all take my license?
Does he have a CDL?
Are you operating a truck?
No, sir, I'm operating the actual machine.
Yeah, but that's not a motor vehicle, is it?
Does he have a license to operate said machine?
Are you talking about construction equipment?
Yes, sir, my job.
Okay, does that require like a CDL to do that?
No, I know we have to have license, and you saying if they're gonna be suspended, I don't know. That's why I'm asking. I mean, I'm gonna take the plea because I need to get out. I'm the only one taking care of my family. So
Well, I don't want you to take a plea just to get out. That's the wrong thing to do.
no, sir,
Can I make a-
I'm doing.
Yeah.
I'm a suggestion, Your Honor.
Hold on here. The public defender is a friend.
It seems like a 6-month suspension is going to put his job in jeopardy. And since the court was willing to accept a credit time served plea, I would ask that you ROR in this case and let the felony attorney on his Allen bond charge, however that resolves, he could assume the MM case downtown.
Don't want me to take any action on
Yes.
outstanding bond and ROR on this?
Yes, only because it's a possession less than 20 grams. If it was something else, I wouldn't be making such a request.
Whatever. What else does he have record-wise?
Oh.
Long history of drug.
The issue I have with that, Your Honor, is the case that he has, that you would have taken action on, also has a possession of cannabis and a paraphernalia. It's a possession of a firearm by a convicted felon and trafficking in means. He has a 2017 adjudication for grand theft third degree. He has a 17 adjudication for resisting. He has a 16 adjudication for accomplice.
Can I respond?
Yeah, but so what the state's saying is it's not your first touch with the criminal justice system. Yes, sir.
Given the circumstances, a bond of $250 between $250 and $500, and then no action on his Allen bond charge is perfectly reasonable, Your Honor, if the court's willing.
Well, state, you have the option of going to the court in the other one for this case and asking it to be revoked, don't you?
Yes.
So another option is if I just let you bond out and not revoke your bond, the state may still revoke it later on or ask the judge to revoke it, but I could take no action on it. If you think that driving suspension would affect your ability to work.
The only way the license won't be suspended if it was a withhold.
Yeah, but with his history,
I'm not willing to offer.
not gonna do that.
Okay, sir, you said that there's a way that even though y'all suspended for 6 months, I go to classes or something?
No, there's the statute talks about. But it takes a while to do all that.
Well,
Okay.
If I gotta do that, I'll do it, sir, because I mean, I'm just trying to take care of my family. I take the withhold, you said plea out to it and they take my license?
Adjudication. It's an adjudication. But I'll be happy to do this. I'll be happy just to, because of the virus, I'll just do the bond only.
Yes, sir.
Keep the bond $250. You can bond out. I won't touch your outstanding bond, but that doesn't mean they won't go back to Division 12 and ask the judge to do something. So, you want to just stay out on bond then? Can you post the bond?
Yes, sir, I can post the bond.
All right, let's just keep it at $250. Do not possess or consume any alcohol or illegal drugs. I won't take action on your case, your other bond, the 2020-3098, but who knows what will happen on that. Okay, and I guess I'll appoint the public defender now to represent you on this drug paraphernalia case.
Yes, sir.
Okay, moving on. Keaton Walton. Are you Keaton Walton?
Yes, sir.
All right, so you're here on a trespass on a property after warning of found probable cause. Now, here's what would have happened. The bond would have been $500 and no return to the racetrack in question. But you're out on bond on another case. So, State, do you have an offer for Mr. Walton?
Second, Your
All right, they're looking it up to see if you want to take an offer.
Sir, I was actually out on pretrial release. I wasn't out on.
Yeah, I know. I know, but I would if I give you the bond, I'll revoke the bond in that one because you picked up the new charge. So.
I don't quite understand.
Okay, well, hang in there. We're going to see what the state says. Oh, you know what? I'm leaving the bond at $500, no return to the property, and I'm not taking action on your other case. Okay? And I'll appoint the PD to represent you. All right, moving on. We got some out-of-county cases. All right, Mr. Is it Prophet?
Yes, sir.
Did I say that right?
Yes, sir.
All right, so Dade, not Miami-Dade County. I was born in Dade County, not Miami-Dade. All right, has some warrants out for you. Essentially, bench warrants called capiases, and they're on a no bond status on the two cases. That's the cannabis sell or deliver with more than 20 grams. And then a cannabis possession, more than 20 grams. Okay, so has Dade County been contacted?
Yes, sir.
Yes, sir.
Oh, no, I was asking pre-trial, but I appreciate that.
Yes, sir.
Okay, where are we at on that? Day what?
Let me check.
Okay, so here's what we're gonna do. We're gonna keep it at no bond, but I don't think Dade County's picking up anybody. So what's gonna happen is you're gonna see one of the judges down there at the BRC where you're at, and then she will tell them to fish or cut bait. And if they choose not to come and get you, she will probably release you, ROR, but you do have to report to Dade County on these charges. Do you understand?
Yes, sir.
Today, we're not gonna do anything. On another case while you're out. And then this is our case, which is the capias on a failure to appear for your arraignment on a possession of cannabis less than 20 grams. The judge set the bond at $2,000. I'll appoint the public defender to represent you on that. Okay?
Do you mind giving me a case number on that?
Yes. It's 2017 MM 3397.
Thank you.
All right, good luck, sir. Ashley Williams. Miss Williams, are you there?
Yes, sir.
Okay. So Charlotte County has a warrant on a grand theft. The bond's $25,000. Same thing with you. They're going to contact Charlotte to see what they want to do on this, and then you'll be brought back in front of IACE to make a determination. So
Would
you
I be
can
able-
bond out right now.
I could bond out right now?
Yeah, there's nothing holding you, right? Is there anything holding her? No. So you could get a $25,000 bond. You would.
Yeah, they told me that I had to see the judge to get the hold lifted off me because I was
What
trying to
hold?
bond out last night.
All right, hold on. Is there a hold on Miss Williams?
No, sir.
Okay, so you can bond out.
Okay, thank you, sir.
Good luck. Are we at what, resets?
Yes, sir.
All right, Jonathan, I'm going to let you pronounce your last name. Schmooky. All right, come on up, Mr. Schmooky. All right, so what this is because you picked up some other charges, Mr. Schmooky, they found out you were on felony probation for selling, manufacturing, and distributing marijuana. And so they did what's called an on-view violation of probation for that. Oh, they didn't charge him? Just took him So, jail, BRC, did he get a ticket or anything for this stop?
You said that he get a ticket for the violation of drug probation?
Well, I guess it's because of the curfew that is what they violated him for, because he was out at 3 a.m. when he wasn't supposed to under his. So that's what it is. It said at no bond, but I'll give you a bond of $500 on it and comply with all your conditions of your probation. Do you understand?
Yes, sir.
All right. And now we got my favorite, the Natty Light docket. All right, Peyton Baker.
Yes, sir.
All right, so you got charged with soliciting without a permit, Mr. Baker.
Your Honor, I take issue with the
Okay.
arrest affidavit here.
All right, I haven't read it yet, so I'll look at it. Go ahead. You tell me what's wrong with it.
The police officer says that he's standing on the curb. He's not obstructing traffic, and he has a sign. That's all. But he wasn't engaged in taking or receiving anything from anyone. He wasn't in the act of soliciting, Your Honor. I don't anticipate the state moving forward prosecution in this case.
But he was displaying the sign that said "Homeless, no work, please."
The sign is enough for solicitation.
Yeah.
But he's holding the sign isn't asking for anything. It's basically just a statement.
He doesn't have to. He's holding a sign in the middle of the road.
He's not in the middle of the road.
You know what? I can't wait to see the Florida Supreme Court opinion on this, but I'm going to find probable cause for it. So, I'll do this. I won't revoke your bond on your other case.
I don't have
And
a,
we'll leave.
I don't have a
Huh?
bond. I don't have a bond on another case.
2020 CF 140.
For the record, Your Honor, I'm his attorney in this out on bond charges.
Did they file? The state filed?
The state filed. I'm in the process of
Yeah,
filing.
you got out on an ROR based on the fact the state didn't file timely, right?
Yes, the state filed an information. I'm in the process.
I'm not going to touch that one, but I'm leaving this one at $250. No return to the scene.
Your Honor,
Finding probable cause. Yes.
my client is not going to be able to afford that bond. Because it's a soliciting without a permit. Would you have any objection to an ROR in this case, Your Honor? I'm actually going to be the attorney taking over the with the soliciting without a permit. I'm going to assume it.
I will give you an ROR.
Thank you very much, Your Honor.
Thank you.
But you've now played your get out of jail card.
Okay.
You'll never get another one. I'll have a judge. So the next time, I'll remind you. Read it. 'Cause all the attorneys get one. You just use yours. You still have yours.
I won't use mine. I don't need it.
Well, let's see. Is Jerry Holly ready?
Yes, Your Honor.
How are you, Mr. Holly?
I'm doing pretty good.
I guess. When did they wake you up for this?
I got picked up at a park the other night. Late.
So you've been up the whole time?
Yes, Your Honor.
Okay. Well, it's been a long day. So let's talk about the things. You got a, first of all, a child support writ of bodily attachment. So we got a special way to deal with those. Essentially, you'll be released as to that charge, but you're going to have to appear on June 2nd at 10 a.m. on the 5th floor
Yes, Your Honor.
before the child support hearing officers on that. Okay? So that takes care of that case. And then you've also got that you were in the park after hours.
Yes, I was walking through.
Well,
and-
no, don't say anything about the facts case. George A. Barker Jr. Park. Okay, so I reviewed it, found probable cause. I'm gonna ROR you on this, don't return to George A. Parker Jr. Park. Can you avoid that place when you go home?
Yes, Your Honor.
Okay. Yeah, okay. We're not appointing PDs on these. All right, so we'll appoint the PD. All right, Bobby McCray. McCree?
Your Honor.
Great, okay. All right, so I'm next going to remind the state that if you have any information on any defendant that the court should be aware of in setting or denying bond, please advise the court accordingly.
Yes, Your Honor.
All right, so I'll now have the attorneys, starting with the state, identify themselves for the record.
Ryan Hagner for the state.
Jace Thompson for the defense, Your Honor.
What? You're still looking for the
That private attorney. What was the defendant name on that private attorney?
Gregory
Can't.
Zachary Cooker. Zachary Cooker. Kueker.
Okay.
Okay, she's pulling it up. We have the interpreter.
Yes, Judge.
Okay, and we're going to start with Julio Gonzalez. Is that you, sir?
Yes.
Sí.
Yes.
Okay.
Your Honor, I'm sorry. The interpreter would just like to ask respectfully if whenever there are case numbers, if the interpreter can get the case number for each defendant.
Oh, I'm sorry.
That's okay. Thank you.
2020 CF 5038, Division 14. All right, Mr. Gonzalez, you have been charged with grand theft, third degree of a motor vehicle.
You know what headphone does it.
And I have reviewed the paperwork and found probable cause. I'm going to appoint the public defender to represent you. I'm going to stay the bond at $1,000. Do you understand?
Yes, I'm understanding.
And Your Honor,
Okay.
the defendant is also on probation. He does have a 5-day hold in place.
Well, has anybody filled out
Oh, no, there's,
an on-view or anything?
there's a 5-day hold in place, Your Honor, so we're going to give the Department of Corrections that 5 days to have that warrant come
Right.
in.
So that means if they decide not to go forward on the violation of probation, you can post it, but you can't get out until that hold
Correct.
expires.
Right, correct, Your Honor.
Okay, just wanted him to know. Thank you.
Yes.
All right, pass
I
that
have an
headset
attorney
on.
for the probation case.
Excuse me?
I have an attorney for the probation case.
He has an attorney.
Okay, all right. Let's talk to Luis Rivera Ortiz. Are you Luis Rivera Ortiz?
Sí.
Yes.
All right, a judge has issued a warrant on the charges of possession of heroin and possession of drug paraphernalia. I'm going to appoint the public defender to represent you. The bond is $2,000 on count 1 and $1,500 on count 2. Is there something here that I should know about Mr. Rivera as far as the bond being at this rate?
Not that the state's aware of.
Now I'm looking at the affidavit here. Well, I'm just looking at this. So the warrant judge wouldn't have had any additional information. Okay, I'm going to reduce the bond to $1,000 on count 1 and $500 on count 2. All right, sir, you can pass that on. Is this Jose Sanchez Barrios?
Your Honor, I'm sorry. Was there a case number for the previous?
Oh, I didn't give you the case number. I'm so sorry.
That's okay.
Here, I'll say it. 2020 CF 1960. Division 17. All right. Okay, is this Jose Sanchez?
Sí, señor.
Yes, sir.
All right, I've got two cases, 2020 CF 5049, and then a 2020 CT, looks like 2694. All right, sir. You're charged with possession of cannabis greater than 20 grams and driving while license suspended or revoked with knowledge. I reviewed the affidavits. I found probable cause for both charges. The bond on the possession of cannabis greater than 20 grams is $1,000. And on the driving while license suspended, it's $500 with do not drive without a valid driver's license. And again, I've appointed the PD to represent you in both of those cases. Do you understand?
Sí, señor.
Your Honor,
Yes,
defendant does have an ICE hold.
Okay, so you you understand that there's an immigration hold on you, that there's a process that they go through. When I was at the jail 10 years ago, I'm sure the process has changed since then, but you understand that they're gonna, until that runs its course, you won't be able to bond out. Do you understand that?
Okay. Sí.
Okay. Yes.
All right, Diego Cardena Osorio. Are you Diego Cardena?
Sí, señor.
Yes, sir.
All right, you're charged with possession of cannabis less than 20 grams. I reviewed the paperwork, found probable cause in case number 2020 MM 3063.
Your Honor. I'm sorry. This is the interpreter. The interpreter couldn't hear what the charge was. If you could repeat that again, please.
Yes, possession of cannabis less than 20 grams. Did you get the case number?
Yes, Judge. Thank you.
All right, so I found probable cause. I'm appointing the public defender. I'm setting the bond at $500. You understand, Mr. Cardena?
Sí, señor.
Yes, sir.
Roberto Corona Perez.
Yes.
bonded, Your Honor.
All right. Elias Cruz. Are you Elias Cruz?
Sí.
Yes.
Luis.
Luis.
Louis, well, they got you. All right, do we have the right Mr. Cruz, Jill?
Sí, le pusieron.
Your Honor, we do.
Okay. All right, well, they have you as Elias Cruz, and they've confirmed your identity.
Yes, we did.
Okay, so this is case number 2020 MM 373. You're charged with disorderly intoxication. I've reviewed the paperwork. I found probable cause. I'm going to appoint the public defender, and I'm going to reduce the bond to $250.
Your
And no
Honor,
return to the scene.
I'm
Yes?
sorry, Your Honor, he does have an ICE hold. I'm sorry.
Okay, you also have a hold by the Immigration Service, Mr. Cruz, and so you won't be able to bond out until that has completed its course. Do you understand?
Sí.
Yes.
All right. Now,
Gracias.
I'm showing the next one's a Vietnamese. Am I wrong?
Yes, Your Honor.
Your Honor.
Yes, I'm wrong, or
No, you're
yes, I'm right.
They're Vietnamese.
correct. She did post bond on the warrant arrest. We needed to address her ICE detainer.
Well, we got to get language line to do that,
Okay,
so we'll do it at the end.
all right.
I'm going to put that. Okay, so now am I up to Ms. Sheila Favier?
Yes, Your Honor.
Your Honor, may the interpreter, Spanish interpreter, be released?
Okay, what, and this right here? Hold on one second. What is this the move up as well? The attorney one?
Yes, the private attorney. Yes.
Private attorney, okay.
Yes, interpreter, you may log off.
So do you want me to do that now or after?
After the meeting.
Okay.
Okay, have a great day.
Thank you, Judge. You too.
Bye. He won't hang out by himself, right?
No, you don't mess with him. He ain't gonna.
Yeah. Ms. Favier, is that you?
Yes, sir, it is.
Okay. This isn't, oh, just forget it. I don't want to repeat myself. Okay, well, you're here on charges as follows. Tampering with a witness, aggravated assault with a deadly weapon, resisting officer without violence, and battery as an incident of domestic violence. I'm going to appoint the public defender to represent you, Ms. Favier. I have reviewed the paperwork and I did find probable cause for the charges. And I don't think we have Peter or Juliet here.
Yes, they are here, Judge.
They are?
Yes, Your Honor.
Yes, sir.
Huh?
Yes, sir.
2 counts of battery, yes. Thank you. Okay, so where are they? Do I move the camera or something? Is that it?
They're present, Your Honor. They're here.
Are they in that viewing room now?
Yeah, yes, they're in the little galley right here.
I can move it? Yes, no, you were. Hit the, I did that.
Hit the video.
Hit the camera? Okay, so I'm going to move over. Oops.
Yeah.
Oh, there they are.
Yes, okay, you got it.
Okay, now, Jill, have you confirmed that this is Peter and Juliet Favier?
Yes, Your
By
Honor.
ID or anything?
Yes, Your Honor.
Okay. Did y'all want to address contact?
We would like to have contact with her.
Okay,
Yes.
so we're going to swear you in. Ready? Raise your right hand.
Right hand, sorry. You solemnly swear to tell the truth, the whole truth, and nothing but the truth?
We do. I do.
I do.
Okay, so, and Miss Sheila Favier, I'm pointing the camera at Juliet and Peter, but I'm talking to you as well. Now, I reviewed the paperwork, I found probable cause, I appointed public defender, but there are 2 options on contact.
Yes.
One is no contact whatsoever with the victims. And the second one is what we call no hostile or violent contact with the victims. So, Miss Juliet Favier, what is your position on this? You want to have contact or you want no contact?
I want to have contact.
You do,
Yes.
which means that she could live there with you on all sorts of things. Okay, and Mr. Peter Favier,
Yes, sir.
same thing?
Yes, sir.
Okay. Now, you understand I can't protect you if I do this.
Yes, sir.
I do. Yes, sir.
I mean, if something happens, you've got to protect yourselves, your family, and then call 911.
I understand.
Because if I go with the no hostile contact, she would be, be able to live there and, God forbid she grabbed a knife or something. I don't know, but I'm just telling you, I can't protect you.
Yeah, I'm not in danger, or I'm not concerned with that at all.
Okay.
I feel
So
no
let me
threat or
hear-
danger.
Okay, so I'm going to hear from the state now. Again, there's been no charging decision in this case. This is just initial appearance probable cause. But let's hear from the state on their position.
Your Honor, the state would object to contact just based off the affidavit and the seriousness of the allegations and the alleged use of the knife. I have no other information to provide.
Okay. So, again, the 2 of you feel that that she could move back in and that you feel that you would be safe.
Yes, sir.
Yeah.
There was no use of knife. There was no actual attempt of use
No.
of knife. I know this is not a trial.
Yeah, I mean, this is just initial appearances. I'm going by what the affidavit. So let me go back. Are y'all using a different courtroom for IAs? That's what's throwing me.
Yeah.
I'm a courtroom 1 guy. Oh, the plus? Okay. All right, Miss Sheila Favier, do you think that's something you could abide by?
Absolutely. Yes, Your Honor.
Okay, so you understand that if Peter or Juliet ask you to take the garbage out, your response will be what?
Take your garbage out.
Okay, so, but if you yell profanity back at them or anything like that, it would be considered hostile or violent potentially, and if they contact police, you'll be back in jail on a violation. You understand that?
Yes, Your Honor.
Okay.
Your
All
Honor,
right, so-
Your Honor, we did qualify Ms. Favia for pretrial release. She has no prior history, no failure to appears.
Okay, so the jail says that you're eligible for pretrial release, and they do an excellent job out there looking into it. So I'm going to, on all 4 counts.
Your Honor, would you have any objections to an ROR in this case? I mean, at her age with no criminal history, no failures to appear?
I appreciate the offer, but I'm going to keep it at PTR. So we'll pretrial release on all 4 counts. No hostile or violent contact with the victims. Don't consume any alcohol or non-prescribed medication. Obviously, do not possess or own any weapons or firearms. Do you understand, ma'am?
Yes, Your Honor.
Okay, so Miss Juliet, Mr. Peter Favier, is there anything else you wanted to tell the court?
No, sir. Did you have
Okay.
anything, Dan? Did you have anything else you want to say?
No, sir, Your Honor.
All right, so they're going to work her up for the pretrial release. I assume they've already talked to her, and they can tell you when she can be picked up. All right?
Okay, thank you.
Thank you, Your Honor.
All right. Ricky Dominicus.
Your Honor, we'll waive their reading their charges.
Okay. Are you Ricky Dominicus?
Yes, Your Honor.
Okay, so there was a warrant issued, and for some public defender, we're not going to say what. We are going to appoint the public defender to represent you. This is at a no bond status. I'm going to leave it at a no bond status, and you can schedule a bond hearing through your public defender with the judge of division.
Your Honor, are you finding proof evident presumption great in this case?
Huh?
Are you finding proof evident presumption great in this case?
Based on what I have, but you need a full Nelson hearing on this, correct?
Well, yeah, but we could also, because I'm just coming from downtown. I mean, from the BRC, I worked out it for the last 7 months, and what we do is we could make an argument as to why you shouldn't find proof evident presumption great here today, and if the defense is unsuccessful in their attempt, then the next stage we'll have to go to a full author hearing.
I'm at Arthur, yeah. So, based on the affidavit for the arrest warrant, I think there's a sufficient level of evidence to hold them without bond. At this point, based upon a proof of guilt evident or presumption, it's great. But what else did you want to say on it?
Well, I just wanted to put a court's consideration that there's no DNA or physical evidence tying my client to the crime, and the only thing that the state is going on, that law enforcement is going on, is the statements by the 2 alleged victims of something that could have happened between 6 and 8 years ago. And all I'm arguing, Your Honor, is that until further investigations are conducted and more substantial evidence is collected, I would ask you not to find proof evident presumption great and possibly set a bond in this case at maybe between $50,000 to $100,000.
All right, Stay.
I would ask the court to maintain its current ruling.
Yeah, so I am, and just you'll need to schedule an Arthur hearing with the judge in Division 17 at this point.
Okay, thank you, Your Honor.
I did. They're all right. There's no contact with the victim and no contact with minor children for the additional provisions. Okay, so we're up to George Moran. You, Mr. Moran, or Montoya Moran?
Yes, Your Honor.
Your Honor, I would ask to wait to reading the charges.
All right,
This is-
so
Excuse me, Your Honor, James Feuerstein, I'll be here on behalf of Mr. Moran.
we have an attorney.
I'm sorry. I withdraw that.
Where's he at?
Is that the attorney?
Yes.
I'm here at the jail as well.
Where are you? Where are you at?
It's a little further to the right.
Okay, hold on. There he is. I bumped in too close. How you been?
Very good, Your Honor. Your Honor, we would waive formal reading of the charges as well.
Okay, so, great, all right, so, this was a warrant with a no bond status, as you know, with also no contact with the alleged victim or her sister. So, are you gonna schedule
Yes, Your Honor, we'll be filing a motion.
downtown in Division?
We'll file a
Division
motion.
19?
We'll be filing a motion to set bond on Monday.
Okay, all right, so we'll keep it at the no bond status at this point with those conditions. Okay, there was no contact with the victim or sister.
All right.
Yes. Okay. Thanks
All
for
right.
coming down.
Thank you.
Are we up to Mr. Dunn?
Yes, Your Honor.
All right, I'm sorry, let me go back. Kind of like the camera thing. I'm kind of enjoying this. There you go. Okay, are you William Dunn?
Yes, I am, Your Honor.
Okay, Mr. Dunn, two things I got to talk to you about, okay?
Okay.
First, there is an allegation that you violated a condition of your pretrial release in your aggravated battery. I'm a duty judge, so I get calls. I reviewed the paperwork and found probable cause. I'm going to appoint the public defender who represents you. This is on a no bond status. And is there anything else you wanted to say about the
Your Honor, may I ask what the charge was, please? I didn't get the charge.
for violating?
Oh, probation?
He was on, yes.
Okay.
Pretrial release on his ag battery as an incident of domestic violence.
I believe he's entitled to a bond for violation of pretrial release, Your Honor.
Yeah. So we can give you a bond on this. And we'll put it at $5,000 and comply with all terms of your lease. But the problem is on that aggravated battery in case number 2020 CF 4450, I'm going to revoke the bond in that case because of this violation. So essentially you're going to have to get with your public defender to go schedule a hearing. You understand?
Yes, I do, Your Honor. I'm a little confused.
We'll talk about the case.
Okay.
I think, was that 20? Yeah, that's it. Okay. All right, so schedule that, talk to your PD, schedule that hearing. Grant Modlin.
Am I allowed to?
Yeah. You're gonna, because you're not getting out today, you want to get with your public defender?
Well, I understand that, Officer. Your Honor. I'm confused on why that says that I have a no contact order and that I violated a no contact order. It doesn't show my signature on a no contact order.
Okay,
My fiance bonded me out and picked me up, so I had no idea about this no contact order.
Don't talk about the facts of the case. State attorney's taking notes. Talk to your public defender on this. This is just probable cause at IAs. No charges have been filed on that yet. But because you did pick up the charge of revoking your bond, so you're not getting out today anyway. You'll have to schedule a hearing with the judge on that. All right, Grant Modlin.
Am I allowed to speak, sir?
Who is that?
That's the victim in this case, Your Honor.
Oh, ma'am, you can't, but we're not going to be able to, I've revoked the bond in the main charge because of this alleged violation. So it's not a question of you having contact with them at this point, because those conditions would still have to be applied. So we're not here to debate the case because this is just probable cause. But if you think there's something I need to know, and it's not about the facts of the case, with the understanding that if you talk about the facts, everything's being recorded, could be used against him later on. What did you want to tell me, ma'am?
I'm also working with the state attorney's office with this
Okay.
and his doctors.
Okay, well, good. I hope he gets all the help he can and we get this resolved. So I appreciate you telling me that. All right?
Okay.
That's not going to change anything. I'm still revoking his bond in the main case. Okay, Grant Modlin. Is that you, Mr. Modlin?
Yes.
Okay. So it's alleged that you committed 2 counts of simple battery. And I reviewed the paperwork.
Yes. The guy pushed me, so I punched him in the face, and then the other guy punched me in the face.
Stop. See, everything's being recorded. Anything you say, the state's going to use against you potentially. So you don't want to talk about the facts of the case. They have not charged you yet. This is just IAs. Trying to determine if there's probable cause. Probable cause is way down here versus charges and the burden of proof they have up there, okay? So I understand what you're saying, but I have to go by what the affidavit says. So I found probable cause for both counts, appointing a public defender to represent you. Now, here's the situation. I'm going to, is he eligible for PTR?
Your Honor, I was requesting more. I did have an opportunity to speak with his aunt, and we have some concerns as far as his mental health status. He does have a mental health detainer, and I'm requesting if we could possibly do bond or mental health pretrial release if qualifies.
Okay, we'll do that.
Thank you, Judge.
Hold on. We're going to do a bond or mental health pretrial release. What?
Well, I'm under the impression that with the mental health pretrial release, he's going to be held an additional 5 days for that to be conducted.
He still has the opportunity to bond out within that time, and this will give enough time for mental health to do an interview with defendant.
So he could bond out today.
Yes.
He could have bonded out before he saw me.
Yes, okay.
So we're going to keep the bonds at 500 on count 1 and 100 on count 2. Now here's the situation, Mr. Modlin. You got to, maintain separate residence. So you can return. If they move out, great. If not, you can return one time with a law enforcement officer. You have to schedule that to get your personal belongings. You can't possess or consume any alcohol or illegal drugs. You're not to have any contact with the victims, okay?
Okay.
Direct or indirect. Direct or indirect, okay?
Okay.
And of course, do not possess or own any weapons or firearms as well. All right, so talk to your attorney, but you've got your bond, and you also have that mental health pretrial release if you're qualified. All right, do you understand?
Yes, I understand.
Okay. Maurice Williams. All right, we'll reset him for tomorrow.
Your Honor, I would waive his appearance.
Okay. So on Maurice Williams, he was charged with trespass on a property after warning, reviewed the paperwork, found probable cause, point to PD, bonds $500, no return to the scene. Okay, so we now have Mr. Is it Cooper?
Cooker, yes, sir.
Yes, Your Honor.
Okay.
Matthews Bark on his behalf.
All right, how are you doing, sir?
Doing well. How are you?
Great. Okay, and Mr. Cougar, you were charged with battery as an incident of domestic violence. Anything on probable cause? Because I reviewed
No,
it.
no, Your Honor. There's no.
Okay,
We're just-
and let's talk about conditions of release. I put down, when I reviewed the paperwork, a $500 bond with the no return. One time with law enforcement, you could pick up your items, no contact, direct or indirect with the victim, don't possess or consume any alcohol or illegal drugs, don't possess or own any weapons or firearms.
Your Honor, we're not stipulating to that, but we'll raise a motion at a later date to address those conditions.
Okay, and then your counsel can schedule a hearing with the judge in this county court case as well. Do you understand?
Yes, Your
Sugar?
Honor. Yes, sir.
Okay.
Your Honor, we did qualify Mr. Kuka for pretrial release, but I did have the opportunity to speak with his attorney, and he wished to post bond instead. I just want to put that on the record. Thank you.
Your Honor, could I have permission of the court to take a picture of his fingernails while we're here by any chance?
Shh, I have no objection. Oh, sorry.
Thank you, Your Honor. Maybe.
All right, we are now on felony domestic, is that correct?
Correct, Your Honor.
All right. Yeah, hey, jail.
Yes.
Do me a big favor, okay?
Yes.
If you've got a victim there that wants to talk, can you tell me when they come up to the podium?
To talk to who, Your Honor? I'm sorry.
If you've got a victim in one of these cases, I need to know at the beginning if they're there or not.
Okay, we do have a victim for this next case, Your Honor.
Okay, so are you McKindy Beaubrien?
Yes, sir.
All right, and there was a warrant issued on aggravated battery on a pregnant person, battery by strangulation as an incident of domestic violence, and a simple battery as an incident of domestic violence. The judge had no bond at the time. I'm appointing the public defender to represent you, and we will now talk. Is it Jessica Reynolds up there?
Yes, Your Honor.
Okay. Jail, you've confirmed her identity, correct?
Yes, Your Honor.
All right. We're going to swear you in, ma'am, okay?
Okay.
Raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, state your full name.
Jessica Lee Reynolds.
Okay, so now, Miss Reynolds, here's where we're at.
Okay.
Another judge issued the warrant.
Okay.
All right. At this point, I've appointed the PD. I'm going to determine the conditions of release. Now, as the victim, are you asking for contact with Mr. Beaubrien?
Yes, please, Your Honor.
Okay. Now, you understand that it is either no contact whatsoever, direct or indirect, or no hostile or violent contact with the victim, which means he can be around you during the pendency of this case while the state is making a decision on whether to file charges or not, which means I can't protect you or your unborn baby if for any reason he becomes violent or hostile. You understand that?
Yes, Your Honor.
Okay. Mr. Beaubrien?
Yes, sir.
Do you understand that if I were to do this, that you cannot be hostile in any way with her?
Yes, sir.
Okay. So, state, well, what did you, do you have any information I need to know?
No additional information, Your Honor. We would just object based on the nature of the allegations.
Okay. So let me ask you, Ms. Reynolds.
Yes, sir.
I mean, you guys live at separate addresses, right?
We do.
Okay, so why do you need to be around them?
Doctor's appointments. I don't feel threatened.
Okay. Do you have any background information on him? Jail? What can you tell me about Mr. Beaubrien?
Your Honor, one, he is on probation for possession of marijuana. His probation ends September of this year. He has 5 felonies for misdemeanors, no failure to appears. His last conviction was September of 2018 for possession of marijuana. He does have convictions, all drug-related offenses, no battery DVs. He does have Florida arrest history for out-of-county warrants, drug possessions, multi-violation of probation, Your Honor.
Okay, but no bodily or domestic
No,
violence?
no, Your Honor. No, Your Honor.
Physical crimes?
Correct.
Okay. All right, so here's what I'm going to do. I'm going to set bond as follows. Count 1 is $2,500. Count 2 is $1,000. Count 3 is $500. I am going to leave it on a no contact, direct or indirect basis, Mr. Bobrin. You can feel free to go to Division 15 with your attorney to request contact. But at this time, I just do not feel that this is one of these cases where I should allow that type of contact going on under the facts of the case. So don't possess or consume any alcohol or illegal drugs. Don't possess or own any weapons or firearms. Again, no direct or indirect contact with the victim. If you call her, you text her, you're in violation. You understand?
If she reaches out to me, do I not talk to her?
Yeah, let's say you got courtside seats at a Magic game when we start playing basketball again.
Mm-hmm.
I mean, you've always wanted these seats, and they're the $5,000 tickets, and you're sitting there, and then she walks in, and 10 rows back, she's sitting. Guess what? You got to get up and leave.
Okay.
Okay, so that's what that means. If she comes in, you leave. She calls, you hang up. She texts, you don't respond.
Okay.
Because that'll violate you.
Okay.
Okay. All right. Thank you, ma'am, for coming in.
Okay.
All right. Are we up to Mr. DeWitt? Are you Devontae DeWitt?
Yes, sir.
Oh, hold on. I'm sorry.
Take your time.
I'm just pushing buttons here. Okay. That's better. All right, sir.
Your Honor, we have the victim present. She's a co-defendant in another case, so she's about to be present. Yes, Your Honor.
Is she, can you not put them next to each other, but can you bring her out?
Yes, she's coming out, Your Honor.
All right. She's got the misdemeanor one, as I recall. Isn't that correct? It's honesty.
Yes.
Chanel Paul. Yeah, hold on. Let me pull that one out. Paul?
Yes.
Hold on a second. I have it. No, these are. It was a misdemeanor one, I thought. Is she charged with a misdemeanor, DV?
She has a felony charge. It's a felony?
Yeah, she's here on a felony. She's out on bond on some battery charges.
Okay, I read.
So go back to the tape. Did I say
This?
no, keep on. It gets back yet. Name is Paul.
Yeah, honesty. I know I read it, so we're flipping. I know it's there. There it is. Found it. Yeah. Okay, so let me back up some more so I can see her. She over there on the left? Where is she?
She is where the attorney was standing, closer to the victim's window.
There.
Yeah.
There you are. Okay, and your honesty, Paul?
Yes.
Okay, so here's what we're doing. We're going to start with Mr. Devontae DeWitt. Okay, so Mr. DeWitt, you're charged with battery by strangulation as an incident of dating violence and then petty theft. And I reviewed the paperwork. I found probable cause for the charges. I'm going to appoint the public defender to represent you on that case. Now, in Ms. Paul, in your case, you were charged with aggravated assault with a deadly weapon and criminal mischief. And I reviewed the paperwork on that case, and I found probable cause. Now, You can't get the public defender. This will be, they'll file a notice of conflict. It'll be sent to the Regional Conflict Council. And if they don't have a conflict, they'll be the ones that'll be representing you at that time. Do you understand?
Yes.
Both can't have the same law firm, essentially. Okay. So now when I read these and I found probable cause on both and I was setting out some bond conditions, first of all, Ms. Paul, you're out on bond on a battery, well, they have been, one of them has been charged, a 2020 MM1701. The other one is 2020 MM2708. And the 2 counts of battery in that one, and then 1 count of battery on that first one. You're in Division 61 and Divisions 85. Now, I'm going to tell you that I'm going to revoke your bond in those cases in light of picking up these new charges. So you're not getting out right away until you talk to those judges to see if they'll give you a bond. I will say this, that at this point in Mr. DeWitt, on your case, I did find probable cause. I'm finding that the bond on count 1 should be $5,000 and $150 on count 2, and you're not to have any contact, direct or indirect, with Ms. Paul, and you're not to possess or consume any alcohol or illegal drugs. You're not to possess or own any weapons or firearms, and that will be the bond on your case. So you do have a bond now with those conditions. You think you can comply?
Your Honor, I did qualify Mr. DeWitt for pretrial release. I did look at his history. He had a couple of batteries, one back in 2000.
Okay, stop right there. If they qualify for PTR, you got to tell me that up front, okay?
Okay.
I don't need to know at the end. I just, because if he's eligible for PTR, then I would say PTR or, and I gave you the bond conditions. He's still going to have all the other conditions I gave as far as that goes.
All right, I'm sorry, you were talking, I didn't want to interrupt you, so that I.
No,
I'll do
right at
that
the
next
beginning,
time.
say,
Okay.
hey, he's eligible for PTR.
All right, I'll do that.
Okay, that's fine. And then, so that's your bond. You've got pretrial release or you've got the monetary bond, but you have all those conditions with concerning the no contact and no weapons, firearms, and things of that nature. Do you understand, Mr. DeWitt?
Yes, sir.
Okay, so Ms. Paul, back on your case, I found probable cause. I can't appoint regional. I got to wait for the public defender to file the conflict, but they will be coming in on this case. And your bond, I'm going to leave $2,500 on count 1, $500 on count 2. No contact, direct or indirect with the victim. Don't possess or own any weapons or firearms. Don't possess or consume any alcohol or illegal drugs. And I'm revoking your bonds in those misdemeanor cases I said earlier. So you'll have to get with your public defender on those cases to see if you can get a bond. Do you understand, Ms. Paul?
Yes.
Okay.
Your Honor, what was the bond on the criminal mischief, please?
$500.
Thank you.
Okay, we're up to Mr. Erder McCombe.
Yes, sir.
Bonjour.
How you doing, sir?
Well, apparently my French is pretty bad, but I'm doing good. Thanks for asking.
Bonjour.
All right. Play with this just a little bit more. Clearly, I should not be doing this. Okay, that's good. All right, Mr. McCombe, you are charged with aggravated assault with a firearm, a child abuse, and battery as an incident of dating violence. I reviewed the paperwork and I found probable cause for the charges. It doesn't sound like you're eligible for pretrial release, correct?
Correct, Your Honor.
Okay. So I am going to give you bonds. You initially being held without a bond, but I am going to give you bonds based on the information provided to me. It's going to be 10,000 on count 1, 1,000 on count 2, and 1,000 on count 3. You're not to possess or consume any drugs or alcohol. No contact with the victims. No direct or indirect. Don't possess or own any weapons or firearms. Do you have any personal items at the victim's house that you need to get?
I do not, sir.
Okay, so I'll leave it at that. So I've appointed the PD, so you got a bond now, all right?
Yes, sir.
All right. Willard Norick? Are you Willard Norick?
Yes, Your Honor.
Okay, Mr. Norick, you charged with battery as incident of the, battery. And tampering with a witness, okay? So here's the good news. Okay, I'm going to give you a bond. It's $1,000 on count 1 and $250 on count 2. You're to have no contact whatsoever, direct or indirect, with the victim. No return to the scene. You can return one time with a law enforcement officer to get any personal belongings. Don't possess or consume any alcohol or illegal drugs. Don't possess or own any weapons or firearms. Now, the bad news is you're out on bond on the attempted burglary of a conveyance in case number 2020 CF 3434. And I'm revoking that bond in light of you picking up the new charges. Make sure you get with your attorney in that other case to see if the judge will give you a bond. You understand?
I understand.
All right.
May I ask you?
John?
May I ask you a question, Your Honor?
Just be careful. Don't say anything that's going to be recorded and they'll use against you.
I won't. Is there any way we could have this resolved today, quickly?
No, absolutely no way. They haven't made a charging decision, so there's nothing to resolve.
Oh, true. Okay.
So no, you're just going to have to work through it and get with your attorneys.
Your Honor, what's the charge? I'm sorry, I didn't.
Be back to me.
I want to understand.
Battery and tampering.
Oh, no, okay. Thank you.
Yeah.
So he said
Okay.
the charge is still pending.
Okay. All right, John Walker. All right, are you John Walker?
Yes, I am.
Okay. So you're here on allegations that you committed crimes of burglary of a dwelling with a battery there, and as an incident of domestic violence, battery by strangulation as an incident of domestic violence, and false imprisonment as an incident of domestic violence. I reviewed the paperwork, found probable cause, and I'm going to appoint the public defender to represent you. I'm going to set bond as follows. It's $5,000 on count 1, $2,500 on count 2, and $150 on count 3. No return to the scene. Do not possess or consume any alcohol or illegal drugs. Do not possess or own any weapons or firearms. No contact, direct or indirect, with the victim. Do you understand?
Yes.
Okay.
I'm sorry, Your Honor, what were the bond amounts?
That was $5,000, $2,500, and $150.
Thank you.
Okay, I believe we're at the misdemeanor DVs. Is that correct?
Yes, Your Honor.
I can get a probation for that charge?
Listen, they haven't even filed charges yet. So this is just probable cause. So you've got your bonds. All right? All right, so Miss Bingle, are you there?
Yes.
Okay, you're Serena Bingle.
Yes, sir.
So I got 5 different things for you. All right? Here we go. The first one is it's alleged that you committed the crime of battery as an incident of domestic violence. I reviewed the paperwork. I found probable cause. I'm going to appoint the public defender to represent you. The bond's $500. no return to the scene, don't possess or consume any alcohol or illegal drugs, no contact, direct or indirect with the victim, don't possess or own any weapons or firearms. So you got a bond in that. Now here's the problem. Broward County, you were out on probation, so essentially you've been charged with what we call an on-view violation of that probation. So there are 4 cases on those where you're on probation out of Broward County, so we're going to hold you on a no bond status on those cases. Now, they're in Broward, so they're going to contact them to see what they want to do. We'll appoint the PD because of the circumstances. And if Broward decides not to transport you, they'll probably bring you back to initial appearances to have you released ROR. Can't guarantee it, but that'll be the situation. So you do have a bond on the new charge, okay?
Thank you.
All right. Is it Ms. LaConstance Dale?
Yes, sir.
Good morning, Ms. Dale.
How you doing?
So I'm doing good. Thank you for asking. So listen, you picked up a new charge. It's a battery. And I reviewed the paperwork. I found probable cause. I'm going to appoint the public defender to represent you. I'm going to set the bond at $500. No return to the scene. No contact, direct or indirect with the victim. Don't possess or consume any alcohol or illegal drugs. Don't possess or own any weapons or firearms. Now, you're out on bond on some other cases. In 2019 CF 14905, it's a false imprisonment with a weapon, aggravated assault with a deadly weapon, and battery as an incident of domestic violence. I'm revoking your bond in that case in light of the new charges. And then in 2019 CF 12074, you also have a battery on a law enforcement officer, domestic violence battery, resisting officer without violence, and resisting with violence. So again, I'm going to revoke your bond in that case. You'll need to get with your attorneys on those cases to schedule a bond hearing. Do you understand?
Yes, sir.
Okay. Ms. Shanna Hallwalker, I probably said that totally wrong, didn't I?
Hello, sir.
How do you say your last name?
Holwager.
Holwager, thank you. Okay, Ms. Holwager, so you're here on a charge of batteries and incident domestic violence. I reviewed, we don't have the victim here, jail?
No, Your Honor.
Okay, I reviewed the paperwork, I found probable cause. She's not eligible for pretrial release?
No, Your Honor. She has some active warrants, one out of Indiana for a probation violation and one out of Georgia for a failure to appear.
Okay, well, welcome to Florida, Ms. Holwager. And so I'm gonna set the bond as follows: $500 on no contact, direct or indirect with the victim, no return to the scene. You're going to return one time to law enforcement officer to get any personal belongings. Don't possess or consume any alcohol or illegal drugs, and don't possess or own any weapons or firearms.
Okay, Your Honor, the apartment, I'm the only one on lease,
I know.
so he's not.
But until you know, if they move out,
Okay.
I'll say maintain separate residence. So if you can convince the jail they moved out, you could move back in there.
Okay.
Eventually.
The other question is, would you consider?
So change that to maintain separate residence.
Would you
ahead.
consider an ROR? I have a alcohol program.
Well, let me call Indiana and Georgia and see what they think.
The Indiana, both of them are
Don't talk about this.
Okay.
Look, it was all a big misunderstanding. I understand, but that's the bond. You got a bond. It's $500.
Okay, thank you.
All right. Good luck.
Thank you.
Larry Lockwood.
Your Honor, I did qualify Mr. Lockwood for a pretrial release, and also he may be a candidate for Veterans Court as well.
Okay, thank you. All right, Mr. Lockwood, is that you?
Yes.
All right, good morning. You're charged with batteries and incident of domestic violence. Reviewed the paperwork, found probable cause. I'm going to appoint the public defender to represent you. I'm going to set bond as follows. Pretrial release. Now, Veterans Court would have to accept him into it. So that is an option as well. And then finally, there's a $500 option if you just want to bond out. Okay? Now, I've got you down. No return to the scene. No, don't possess or consume any alcohol or illegal drugs. Don't possess or consume any, don't possess or own any weapons or firearms. Obviously, you want to maintain a separate residence. You can return one time with the law enforcement officer. Get your personal belongings. And I did not say that, did I? Thank you. And no contact, direct or indirect, with the victim. Do you understand, Mr. Lockwood?
Could I speak with?
They're saying straight pretrial release.
Yes.
Straight pretrial release without the bond, Your Honor, because I qualified him
Yeah,
for
it's
straight pretrial.
or. Yeah, but see, the problem with that straight pretrial is
Yes.
they'll say, well, I just need this thing. They don't get it, and they sit there. So I always want to give them that. Some people don't like pretrial release. I know, but I'm telling you, some people don't like PTR. They'd rather pay a bond than PTR.
And, Your Honor, I'm
Yeah.
sorry, Your Honor, we discussed this downstairs when we actually interview the defendants. So we do discuss if they do qualify, we do qualify them for the straight PTI,
Right.
not unless we didn't have the opportunity to interview them at the time.
No, I think pretrial release is great, but it gives them an option in case they don't want to do it. Gives them a monetary bond. Okay, William Malachi. Who is that?
Qualified-
Jessica Blunt?
Yes, we did qualify Mr. Malachi for straight pretrial release, and we had the victim present.
Okay, so are you William Malachi?
Yes, sir.
Okay, so you're charged with battery as an incident of domestic violence. And I believe that's Caitlin Marciano over there?
Yes, Your Honor.
Okay, hold on. And Jail, you have confirmed her identity?
Yes, Your Honor.
All right. And ma'am, did you want to talk about contact? Is that why you're here?
Oh, yeah. No, we're fine.
Okay.
It's fine.
Well, hold on. So we're going to swear you in.
Okay.
Raise your right hand. You swear? Or friend, testimony shall give me the truth, nothing but the truth.
Did you hear that?
Yes.
Okay, yes, you do. Great. Okay, so I reviewed the paperwork. I found probable cause on this, and he is eligible for pretrial release or a $250 bond. Now, when I read the paperwork, I wrote notes that said no contact, direct or indirect, with you as the victim, Ms. Marciano. Do you want to have contact with him?
Yes, I do.
Okay, so if I did that, we would change it to what's called no hostile or violent contact with the victim. In other words, if he comes violent or hostile with you, he'd be in violation. Do you understand?
I understand.
And you feel that you feel safe in this regard?
Absolutely.
Okay, so is there, Jail, do you have any information about prior domestic cases with Mr. Malachi?
No, Your Honor, he has out-of-state convictions, which was the last one back in 2010 for a robbery. He has no Florida history.
Okay. So, Mr. Malachi, you understand that if I do this and, she tells you to go wash the car and you say some cuss words at her and she feels that you're being hostile, she could violate your pretrial release. She'd be back in jail on a no bond status. So do you feel that you could go back and be without hostility or violence toward her?
Yes, Your Honor.
Okay. So what we'll do then is we'll again, $250 for pretrial release. No hostile or violent contact with the victim. I do not possess or consume any alcohol or illegal drugs, and do not possess or own any weapons, firearms. So, Ms. Marcio, that means if there's any alcohol or any guns, they got to be cleared out of the house, or he's going to be in violation. Do you understand?
Yes, Your Honor.
Okay, so you they're gonna, as soon as they finish the paperwork, you can process them out. They may get them out on the PTR first, but he should be out today, correct, Jill?
Correct, Your Honor. If we do the pretrial release, I don't know if she wants to do the bond or PTR. That's something.
Yeah.
I don't even know the difference. Can you explain it to me?
Yeah, I mean, again, it's just an option in case one falls through. Okay, thank you very much. Miss Jessica Valencia,
Thank you.
come on up.
Oh, yeah.
Is that you, Miss Valencia?
Yes.
All right, good morning.
I'm sorry, Your Honor, we did qualify Ms. Valencia as well.
Okay. So, Ms. Valencia, you're charged with batteries and incident of domestic violence. I reviewed the paperwork, and I found that there is probable cause. And I assume Ms. Davis is not here. Is that correct, Jill?
Correct, Your Honor.
Okay, so here's what I got to do. I'm going to set the bond at pretrial release or $250. But because I haven't heard from Ms. Davis, I'm going to have to keep it at a no contact, direct or indirect with the victim, which means you have to maintain a separate residence. You can return one time with law enforcement officer to get your personal belongings. Don't possess or consume any alcohol or illegal drugs. Don't possess or own any weapons or firearm. Do you understand?
Yes, Your Honor.
So be very careful, Ms. Valencia. So that means not only can you not call or text the alleged victim, you can't accept any calls or texts from them as well.
I have
It'd be a violation. Yes.
The lease,
Go ahead.
the apartment is mine.
Well, it says maintain a separate residence. So if she moves out, then you can move in. But if she's there, you're going to have to go see your judge in your case to talk about changing that. I know it is what it is. I hear what you're saying. Okay?
Yes.
All right, good luck. Maria Valenila?
Your Honor, we did qualify Ms. Villanila for pretrial release, and we do have a victim present.
Okay, great. Are you, and is it Valenila?
Vallenilla.
Valenila. All right, thank you.
You're welcome.
Okay. All right, so let me move over. Okay, sir, what is your name?
Is it Jordan Townsend?
All right. Jail, you confirmed that is him?
Correct, Your Honor.
All right, so we're going to swear you in, sir.
Raise your right hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth.
I do.
State your name for the record.
Jordan Townsend.
Okay, sir. So as you know, Maria has been charged with batteries and incident of domestic violence. I had reviewed the paperwork, found probable cause. Are you here for the purpose of contact with her? Are you asking for contact, or are you asking the court to keep her away from you?
Yeah, contact is preferred. I actually didn't expect this response. It was just more of a mediation type of thing. So
Yeah, but we don't want to go into the facts of the case because the state hasn't made charging decisions yet. So you want what we call no hostile or violent contact with the victim.
exactly.
And you feel safe in that regard?
Yeah.
Okay, so let me get back to. All right, ma'am, did you hear what he said?
I did, Your Honor.
And you feel that you could, if you get back, you could avoid any hostile or violent contact?
Yes, I can.
And when he says, what's for dinner? Your response is not, fix your own blankety blank dinner. It is, what would you like, dear? In other words, you want to avoid any type of hostile or violent contact with them. You understand that?
Understood.
Okay. So what we'll do is again, I'll point the PD, but it would be, bond will be pretrial release or $250. No hostile or violent contact with the victim. Do not possess or consume any alcohol or illegal drugs, and do not possess or own any weapons or firearms, which means that if there are any in the house, the home, you've got to remove them or she will be in violation of her pretrial release. Okay?
Okay.
All right, so they should cross you out today.
Thank you.
All right. Miss Tina Wilkerson.
Yes, sir.
Is that you, Miss Wilkerson?
Yes, sir.
Your Honor,
Okay.
we did qualify, excuse me, Your Honor, we did qualify Ms. Wilkerson for pretrial release. There is no victim present.
Okay, so I read everything, Ms. Wilkerson, this morning, and I found probable cause for the charge. I'm going to point to PD, but here's what I wrote down on the notes. I'm going to release you on your own recognizance. You're to have no hostile or violent contact with the victim. You're not to possess or consume any alcohol or illegal drugs. You're not to possess or own any weapons or firearms. You understand?
Yes, Your Honor.
Okay.
Thank you.
All right, so we are on the felonies.
Your Honor, we have an attorney here for the next person. He's in traffic. Palomar Miguel.
It's a traffic case?
Yes, Your Honor.
You want me to stand?
You have a mask. If you put your mask on, you can stand.
Can't talk. I can't talk.
Or if you want to, you can stand right over there.
Miguel Palomar?
Yes, sir.
And he has an attorney.
All right. Where's counsel?
Joel Leopard, Your Honor. I'm gonna move over here. I'm just
You
gonna.
gotta stand over there. If
Do
you
I
want.
stand?
There. Oh, there you are.
See you, Judge?
There?
Okay. Yes, Your Honor.
Wherever you want to be. Doesn't matter to me.
Okay.
He's not gonna wear his mask. You gotta stand over here.
Okay. All right. I can't talk at the same time with this mask here.
Stand right here.
Okay.
You can move the screen.
All right, so we got Miguel Palomar, we've got counsel, and this is a warrant that was issued. Is that correct?
Yes, Your Honor. We have a
And it's
Sorry, go ahead.
it's a warrant for a violation of pretrial release,
Yeah, come on, look.
and the judge set it at a no bond status.
Yes, Your Honor.
Judge Cameron.
Yes, Your Honor.
So what is it you want to talk about?
Yeah, so we've got a motion to reinstate pretrial release or to set bond as unopposed. I emailed Your Honor the motion as well as the position of the state, ASA Danny Simpkins. We're unable to get the motion over to Judge Cameron before the close of business. Mikkel has no prior history. He actually has a job right now working at Skechers and helps to support his disabled mother. So it's just a situation where he's accused of searching through a neighbor's house for his keys with a couple of buddies. He's not a career criminal. And it's an unfortunate situation, but we could have got it sorted out if we would have had a couple more hours.
Okay, so are you saying the state has no objection?
Yes, Your Honor. And I have the state's email that I forwarded to you. Hopefully I got the correct email.
Division 62 prosecutor?
Yes, Your Honor. That's ASA Dania Simpkins.
All right, so let me just see. Do you have any reason, state, to believe that the state attorney in that division?
No, I'll take counsel's word.
Okay. Just looking. Okay. So it appears Dania Simpkins agrees to put him back on pretrial release. So we're going to ROR him on this and put him back on? What does your order say?
The proposed order is blank, Your Honor. You know, either is acceptable to us. Pretrial release is great. ROR is great.
Put him back on the conditions of his original. It was a pretrial release on the last one, wasn't it?
Yes, Your Honor.
Okay, so we're going to grant your unopposed motion to reinstate pretrial release or set bond, and we will reinstate pretrial release.
Thank you very much, Judge.
Okay, thanks for coming by. Stay safe.
Your Honor, I'm sorry, so that's a bond or PTR? Or
No,
bond?
just reinstate his pretrial release,
Okay,
yes.
okay.
Yes. Okay, are we up to Emmanuel Brown?
He refused, Your Honor.
All right, we'll reset him for tomorrow.
Your Honor, I'll waive his appearance.
All right, hold on. PD's waiving his appearance. So on Emmanuel Brown, he's charged with grand theft, third degree of motor vehicle, resisting officer without violence, read the paperwork, found probable cause. Stay the bonds at 1,000 on count 1 and 500 on count 2. So he has his bond. All right, we're up to Nicole Picasso Ladiva. I can't pronounce that, so excuse me.
He wasn't on our list, Your Honor.
He's not?
No.
Your Honor, do you have a booking number, please? May have bonded.
Here. Hold on.
Okay.
2000-9931.
Bonded.
Great. David Doria?
Yes, Your Honor.
Okay. So you're here, Mr. Doria. It's alleged that you committed crimes of tampering with physical evidence, possession of fentanyl, possession of cocaine, possession of cannabis less than 20 grams, and possession of drug paraphernalia. And I read the paperwork and I found probable cause. I'm going to appoint the public defender to represent you. I'm going to keep the bonds at 1,000 on count 1 and then 150 on count 2, 150 count 3, 100 on count 4, and 100 on count 5. Do not possess or consume any alcohol or illegal drugs. Do you understand?
Yes, sir.
All right. We're up to Damius Goodman.
Yes, Your Honor.
Okay. How you doing, Judge?
I'm doing good, Mr.
Okay.
Goodman. How are you doing?
Okay, I have a question.
Well, don't talk about the facts of the case, but go ahead. My
Okay.
favorite color is blue, but any other questions?
Okay, I'm just here for issue. I just here for a bite. I just want to go home with my family. I just want to get.
Well, that's not going to happen today.
Okay. I have.
So I'm sorry.
Tabon.
It's not going to happen today. So let me go over this with you, and I'll tell you why. You're charged with burglary of an occupied dwelling.
Okay.
I read the paperwork. I found probable cause. I appoint the PD to represent you. I'm setting the bond at the $5,000 and no return to the scene, no contact with the victims.
Okay.
But you're out on bond.
But I was.
Hold on. Yep. Don't talk about the facts. Let me finish. You're out on bond on a 2020 CF 2261, 2020 CT 1275, and 2020 CT 1276. And I'm revoking your bonds in all those cases in light of these new charges. So you can talk to your attorneys in those other cases to schedule a bond hearing, but you are not going home today.
Okay.
All right, Mr. Goodman?
All right.
All right.
That's great.
Jeremiah Hutto.
Yeah. How you doing?
Good morning, sir.
Morning.
I got two things I want to cover with you. First, I got a warrant for your arrest in a petty theft with 2 priors. And the judge set the bond at $5,000. In that case, and I'll appoint the public defender to represent you. In the other case, you picked up new law violations for trespassing and structure or conveyance and petty theft with 2 prior convictions. And I am going to find probable cause on those, and the bonds will be $500 and $1,000, no return to the scene. You understand?
Yes, sir.
All right.
Thank you.
Paul Jeff, I want to say Jacaz. How do you say it?
Haka.
Aka. So it's Spanish. The J is silent.
Yes, sir.
Aka. See, that 4 years of Spanish is paying off for me. Huh? Hold on a second. Yeah. Well, okay. All right, sir. It's alleged you committed the crimes of possession of cocaine with intent to sell or deliver, possession of a controlled substance, which was marijuana, possession of LSD with the intent to sell or deliver, and then resisting officer without violence.
Your Honor, could I be heard as probable cause to
All right, so I'm going to appoint the public defender to represent you. Go ahead, counsel.
I would just like you to find probable cause for the possession charges. As for the intent to deliver, there's no evidence that my client intended to distribute any narcotics in this case. There's no confessions or admissions by my client. I think the officer just based on a certain amount of quantity or the way the drugs could be packaged. But there's no substantial evidence to point to intent to distribute or whether it's for personal consumption, Your Honor, recreational use. I would just ask you not to find probable cause for the intent to distribute and just find probable cause for the possession charges.
All right, stay.
Your Honor, I do believe there is probable cause for the intent to distribute based upon, as counsel noted, the packaging, the types of substances, the variety, and the fact that there was U.S. currency located in small denominations, and the way that currency was rolled up into a tube shape. I do believe there's probable cause.
That's word. Anything else?
Your Honor, just because currency is tied up in it, manner doesn't necessarily mean that it's indicative of a person's intent to distribute. I mean, people have different quirks and various things of that nature, Your Honor. I'll just actually find probable cause for possession.
Okay. Well, based on everything I've read and heard, I'm going to find probable cause for all the charges. I'm going to stay the bonds at $15,000 on count 1, $1,000 on count 2, $1,000 on count 3, $500 on count 4. Do not possess or consume any alcohol or illegal drugs. All right. I have Christian Jordan.
Oh, that's it.
All right. Are you Christian Jordan Otero?
Yes.
All right. You're here because another judge had issued a warrant, and it is on destruction of evidence and resisting officer without violence. The bond was set by Judge Apt at $1,000 on count 1 and $100 on count 2. I'm going to appoint the public defender to represent you. Jail, is any history here? Is he eligible for a PTR?
Your Honor, we didn't qualify defendant for pretrial release. I'll defer to the court, being that it's a warrant arrest.
Okay. All right, I'm going to leave the bonds at $1,000 and $100 on there, and again, you've got the public defender to represent you, sir. Lorenzo King?
Qualify Mr. King for pretrial release as well.
Yes, sir.
You did?
Yes, Your Honor.
Okay, great. Are you Mr. King?
Yes, sir.
Good morning, sir.
Morning.
You're here because it's alleged you committed the crime of burglary to an unoccupied structure. And I reviewed the paperwork and I found probable cause. I'm going to appoint the public defender to represent you. I'm going to set the bond at pretrial release or $2,500. No return to the scene. You understand?
Yes, sir.
So if you get qualified, and you'll be out on pretrial release, but do not return to the scene.
Yes, sir.
All right. Heather Paris, is she here?
She bonded out, Your Honor. Come on.
All right. How about Robert Parks? Is he Paris? Sorry. Is he here?
Sir. Honor.
All right. Good morning, Mr. Paris. It's alleged you committed the crimes of burglary of an unoccupied structure, burglary. Hold on. Let me
I'm
finish.
sorry.
Burglary of an unoccupied conveyance, and then this violation of this disaster preparedness. Apparently, during the curfew hours, these alleged crimes occurred. This was all during the state of emergency that we're still under. I'm going to appoint the public defender to represent you, Mr. Paris. I did find probable cause for all the charges. I'm going to set the bond as follows: $2,500 on count 1, $500 on count 2, and $250 on count 3, and no return to Mullinax Ford. Do you understand?
Yes, Your Honor.
All right. Reginald Pearson.
Yes, sir.
Good afternoon, Mr. Pearson.
Good afternoon, sir, Your Honor.
All right, you're charged with burglary to an unoccupied structure, and I reviewed the paperwork and I found probable cause.
No, I'll have probable cause.
Oh, I'm sorry. Hold on. Before I announce probable cause, I've appointed the PD and they want to argue it. So go ahead.
Per the arrest affidavit, the the alleged victim in the case or alleged property owner stated that the home is vacant and that there was a 2-week gap before she witnessed the alleged damages on the inside, Your Honor. My experience in felony court, Your Honor, I believe the state's gonna have a tough time proving that Mr. Pearson was responsible for the damages therein, Your Honor. There's no substantial evidence to prove or suggest that Mr. Pearson even had anything to do with those damages. But when the alleged victim and independent witness says that they saw him on the property, I believe that is enough probable cause for a trespass, but not for a burglary, as the burglary is the intent to commit a crime therein. There's no substantial evidence that he committed a crime inside the residence, Your Honor. I would ask you to find probable cause for trespass.
Stay.
I'm sorry, Your Honor, if I could just have a second.
Mm-hmm.
Your Honor, I'm not going to contest that.
Okay, so we'll find probable cause then for a trespass. So I'll set the bond at $500 and no return to the scene. Do you understand?
Yes, sir.
All right. Trespass. Do you have the statute number on that trespass?
No, I'm sorry. I can look it up though.
Sharon says she's going to find it for you.
Thank you.
Is it? Well, it would be probable cause for a trespass of a structure.
It's a simple trespass, Your Honor.
Yeah. So, yeah. Okay, Mr. Powell, is that you?
Yes, sir.
All right, sir. You're charged with possession of crystal meth, possession of cocaine, and possession of heroin. I'm going to appoint the public defender to represent you. I found probable cause. I'm going to stay the bonds at $1,000 on count 1, 150 on count 2, and 150 on count 3. Do not possess or consume any alcohol or illegal drugs. You understand, Mr. Powell?
Say that one more time, sir. So how much would I have to pay to get out?
It's the same amount when you came in. 1,000 on count 1, 150 on count 2, and 150 on count 3.
What? So 300?
Plus 1,000. All right, Deanne.
Is the court revoking his bond in his open case?
What bond? I don't have it. I don't show he's got an open case.
Yeah, we don't have that either, Your Honor.
Yeah, so y'all can do what you need to do.
Yes, Your Honor.
All right, how about D'Angelo Randolph?
How you doing today, sir?
I'm doing well, Mr. Randolph. All right, so here's what we got. You ready?
Yes, sir.
We got us, first of all, the arrest warrant that was issued for the fleeing or attempt to elude police officer, lights and sirens engaged, and a no valid driver's license. The bond's $10,000 on count 1 and $150 on count 2. And do not drive without a valid driver's license.
Yes, sir.
And again, I'll appoint the public defender for you on that warrant. Then you have also have a warrant for a burglary of a dwelling and petty theft. And in that case, and I'll appoint the public defender, it's $25,000 on count 1, $1,000 on count 2, and no return to the scene of the offense, and no contact with the victim.
So,
Now, hold on. Yeah, so the bonds are the same. So 10,000, 150, 25,000, 1,000. Now, he is out on bond in case number 2020 CF 575. And he bonded out on January 18th, 2020 on those. The offense dates on these other ones is the second one was March 23rd, 2020. And the first one, offense date was, well, I guess the first one I read was April 1st, 2020. So in light of these crimes having occurred after you went on bond in that 2020 CF 575 case, I'm revoking your bond in that case. So I've appointed the PDs, although I gave you bonds on the new warrants, I'm revoking your bond on your older case.
All right,
You
sir.
understand?
Yes, sir. But is there any way you could like drop some of the bonds?
I'm not going to touch the bonds.
The burglary
but you
of a
feel
dwelling?
free to talk to your public defender about going to the judges about getting your bond reinstated and lowering the bond on the other warrants. All right. Julio Romero. All right. Is that you, Mr. Romero?
Yes, sir.
Okay. So a warrant was issued on a possession of a controlled substance, second count of possession of controlled substance, and possession of drug paraphernalia. It's what we call a bench warrant, a capias. And the reason it was entered is because you allegedly failed to appear for your trial management conference on January 16th. So they've revoked your release and you're set at a zero bond status. I'm going to appoint the public defender to represent you. They can go back to the judge in Division 11 to see about reinstating your bond. Do you understand?
I already took a plea on that case.
Okay, so you pled out on that case, huh?
Yeah, they gave me time served.
Hold on, 2019 CF 12631.
Yes, sir.
All right, we're going to check. No? Julio Cesar Romero. No? Okay, you're going to have to contact your attorney to find out what's going on. Do you have the public defender?
No, sir. I forgot who he was.
Okay, well, we're showing you got the public defender, so talk to them, whoever the attorney is, to get you a hearing to find out what's going on. Because if you had pled out on this case, I'm not sure why you're here. So they're showing you didn't
What
plea out on
happened?
this.
Can I explain to you, Your Honor? What happened was that they suspended I took the plea. They suspended it for the other week on top, and I made it to the courthouse, but I made it late, and they decided not to see me. To
Listen,
sign, but
I
it was
can't
to
do
sign
anything
off.
about that. I hear what you're saying, but I didn't issue this. Another judge did, so I can't do anything. So schedule a hearing as soon as you can to get this all cleared up.
Thank you, sir.
All right, Stephen Sears.
He refused, Your Honor.
Okay.
I waive his appearance, Your Honor.
Well, he's got a trespass that he's ROR'd that I would revoke if I do it. So you want to just wait?
Oh, yeah.
Huh? You can reset for tomorrow. Is Willie Sip there?
Yes, sir.
All right, Mr. Sip. You're here because it's alleged you committed the crimes of possession of cocaine and possession of drug paraphernalia.
Yes, sir.
I'm going to appoint the public defender. I reviewed the paperwork. I found probable cause. Bond's $1,000 on count 1 and $250 on count 2.
Your Honor, would you have any objections to an ROR in this case? He's charged with.
He's out on bond on an ROR and another drug case, so no. But thank you for asking. So I reduced it a little on count 2, and also do not possess or consume any alcohol or illegal drugs. Count 2 will go to 250. Yeah. But, as they say, you're out on bond in 2020 CF 4675 on drug charges. I am revoking your bond in that case. So make sure you get with your attorney to schedule and again, we'll appoint PD to represent you. You understand, sir?
Yes.
All right, Jeremy Trout.
He bonded, Your Honor.
All right. How about Kadeem Wright? Good afternoon, Mr. Wright.
Good afternoon.
All right. So I've got two things for you. The first one is a possession of cocaine, possession of meth, possession of a second count of meth, possession of drug paraphernalia, 2 counts, trespass in a dwelling after warning, and resisting officer without violence. I'm going to appoint the public defender to represent you. I found probable cause for the charges. I'm going to stay the bonds at what they are, 1,000, 1,000, 1,000, 500, 500, 500, and 500. No return to the scene. Then the other case that you have, it's a misdemeanor case. It's a petty theft of $100 or more. Again, I'll point the PD, found probable cause, and the bond's $500 and no return to the scene. Do you understand, sir?
I don't got no petty theft case. I don't see that one.
Yes, you do. So you had 2 cases, a felony and a misdemeanors. All right, Michael Wright.
Your Honor, he's on a notice to appear for trespassing, case 2020 MM 168AA.
Mr. Michael Wright is?
No, Kadeem Wright, Your Honor.
Hold on. Let me go back.
Okay.
Well, we don't have it.
Okay.
So I'm not going to touch it. The state can go
Okay.
talk to the judge in that case. What was that case again that you said he's out?
Your Honor, it's 2020 MM 168AA.
I'm just going to put no action because I don't have the paperwork.
Okay.
All right, Michael Van Wright. Is that you, Mr. Wright?
Yes, sir.
All right, so you got okay. See, I'm looking, hold on, I'm looking for the other ones. I don't see it. Okay, so what I have in front of me is driving a license revoked with knowledge with 3 prior convictions, okay? And I'm going to appoint the public defender to represent you. I'm going to set the bond at $2,500. Do not drive without a valid driver's license. But you have an Osceola case that you're out on bond in 2020 CT 1000. And I am going to revoke your bond in that case in light of these new charges. You can get with your attorney to see if they'll give you a bond. All right, we are at okay, let me know if they bonded out as I call their names out. Wally Julian,
No, Your Honor, I have not bonded out.
Wally Julian, is he bonded out?
He's standing at the podium.
No, Your Honor.
He said,
He's at the
are you
podium,
Wally
Your
Julian?
Yes, sir, I am.
Well, why do you say no?
He's standing right here at the podium, Your Honor.
Oh, because no, you didn't bond out.
No, sir, I did not
Wait,
bond
so I was
out.
talking to pretrial. That's okay. Well, thank
Sorry,
you.
Your Honor. The only person that bonded, Your Honor, was Lord Mendez Emmanuel. He did bond out. He's a traffic.
Okay.
Yeah, he bonded.
All right. So here's what we got for you, sir. First of all, you were arrested for driving a license revoked with knowledge. and I'm going to appoint the public defender to represent you. And I'm going to set the bond at $500 and do not drive without a valid driver's license. But you've got a warrant out of Sarasota County, and it's for, it's a 2018 CF 7971 case, and it's a violation of probation on your, it's a felony with a gun, and they are set you at a no bond status. So we're going to contact Sarasota. Have we contacted them yet?
Let me see, Your Honor. Let me check my notes.
No. So we're going to contact them, see what they want to do. If they don't want to do anything, they'll bring you back to IAs.
Yes, sir.
All right.
Your,
And then
Your Honor,
let
may
you
I ask
know.
a question, please?
Sure.
Thank you. It states that it's for the concealed weapons with ammunition, but I was on probation with 2, and I already completed that part of the community control. So it should have been something else, unless they put that whole me on probation for concealed weapons as a whole
I
instead.
think concealed weapon with ammunition was the original offense. So
Yeah.
here's what's going to happen. They're contacting Sarasota. They're going to let us know what to do.
Okay, thank you.
It's probably a good chance they're not going to do anything because of this virus, and they'll probably ROR you. You'll still have to report to Sarasota on that,
All
and
right.
you'll still have to postpone on the new law. Okay?
So this will be up to 7 days, correct, sir?
Well, typically we say 7, but I don't know what the jail's been doing lately with the virus.
All right. Thank you, Your Honor.
That's what I said when I was sitting at the jail. So we'll see. All right. Good luck.
All right,
Emmanuel
have a blessed day.
Lord Mendez.
He bonded, Your Honor.
Oh, is that the one you were
He
telling me?
bonded,
bonded
yes,
there?
yes, Sharon, he bonded.
I wasn't listening. Sorry.
Yeah.
All right. Keandre Thompson. Is she there?
Bonded, Your Honor.
She bonded.
Okay. All right. Are y'all taking pleas through the video?
I'm not too sure, Your Honor. Is he taking
What do you-
pleas?
Anybody know?
Now, you oral please over the.
Yes, yeah, we're able to take, please.
Did the video?
Yes.
You're doing it? Okay. So I got, hold on a second. I got a Mr. Carlos Benjamin.
What happened to Andrew?
Your Honor, we have a Jose Juan Andiger standing at the podium, and we have Mr. Benjamin behind him.
Okay, I'm just going by what's in front of me. So who's at the,
It's a Jose Juan Andujar, Andujar.
hold on a second.
Okay.
Emmanuel bonded, right? This Emmanuel bonded. Yes. Traffic case.
Yes, correct.
Okay. We have the next person to be a Thompson. Thompson bonded.
Thompson bonded.
Okay, so she's bonded. Then we have Jose Juan. He's at the podium.
He's at the podium, correct.
Where's his paperwork? You show me.
This is
Let's see it. Apparently the judge lost it, so hold on.
is he a reset?
No.
No, he's a misdemeanor pliable. The first one on misdemeanor pliable.
Hold on. Looks like maybe we got stapled. Oh, the judge takes full responsibility for the last thing. All right. Jose Andujar?
Yes, sir.
All right, good afternoon.
Good afternoon.
Okay, so you're charged with a threat, and it's under the law enforcement public officer family member. Now, I'm not going to appoint the PD yet, but what is the offer on this? Don't have one? You want to leave it to the court?
I will leave it to the court, Your Honor.
Okay. Jail, anything you want to tell me about him?
Your Honor, he does have his last conviction was back in 2016 for a battery. He was released in 2006 for a robbery. He does have a Florida conviction for battery and a robbery charge, a Florida arrest for multiple violation of probations, aggravated assault with a deadly weapon, a battery, resisting without violence, and tampering with a witness and victim. And he
Okay,
does have
so look.
other states as well, Your Honor.
I'm not comfortable taking a plea on this right now, based on the facts of the case. I found probable cause. I'm going to set the bond at $500. Do not possess or consume any alcohol or illegal drugs. Point the PD and they can schedule a plea for you. Do you understand?
Yes, sir, I do.
All right. So are we up to Benjamin Serrano?
Yes, Your Honor.
All right. Carlos Benjamin Serrano, is that you?
Good afternoon, Your Honors.
Good afternoon. All right, so you're charged with criminal mischief. State, are you making any offers?
I will leave it to the court.
What do we know about Mr. Benjamin Serrano?
All right, Your Honor, he was released from DOC back in 2008 for aggravated assault with weapon, criminal mischief out of Miami-Dade. His last conviction was 2008 for aggravated assault. He does have Florida convictions for possession of cannabis, criminal mischief, aggravated assault. He has no out-of-state history. His Florida arrest consists of a premeditated murder that was back in 2006, battery, aggravated assault, possession of drug paraphernalia, trespass.
All right, so, sir, I don't think I'm going to be giving you an offer today in this. So I'm going to point the PD to represent you because I found probable cause. The bond is $500, and no return to the scene, no contact with the victim. You understand?
Yes, Your Honor.
All right, are we up to Cabrera Ramos?
Yes.
I waive the appearance.
Mean the reading?
No, he said that he refused, so I waived
I
his.
know, but he's got prior convictions. I'm gonna revoke. You want to wait?
No.
Okay. So he got arrested for trespass and occupied structure, found probable cause, point PD. Bond's $500, no return to scene. I'm going to revoke his bond on the petty theft, which is the Osceola 2019 MM4083, and the resisting officer without violence, which I believe is an Orange County case, 2020 MM2580.
So, Your Honor, was the bond?
The bond was $500 on the new case. All right, so we up to Miss Betsy Carr.
She's behavior, Your Honor.
I'll reset for tomorrow. How about Roberto Hernandez? Is that you, Mr. Hernandez?
Yes, I'm here, sir.
All right. So you were arrested for a simple battery. I'm going to appoint the public defender. I reviewed the paperwork. I found probable cause. The bond's $500, no contact with the victim. But you are out on bond in some other cases. You have 2-count battery case in 2020 MM2151 and a trespass of an occupied structure in 2020 MM2105. I'm going to revoke your bonds in those cases in light of the new charges. And again, I'll point the PD to represent you. You can schedule bond hearings with those judges. You understand?
Yes, sir.
Edward Hayward.
It's odd that Your Honor.
All right. Okay, so what am I up to? The out-of-county warrants?
Yes, Your Honor.
Charles Wethington, is that you?
Yes, Your Honor.
Come on.
Okay, so here's what we got, Mr. Wethington.
It's a paperwork error, Your Honor.
Huh?
It's a paperwork error.
Wethington? Yeah, hold on a second. Let me get something. Wethington? No. No,
He's a new one. Yes,
new one.
he's a new applicant. So it's County.
Yeah. So So here's the deal. It's a alleged violation of probation on a DUI, and they've hold on a second. This is I'm showing it as a 5,000 on the VOP. On the VOP, and then CS 2247. Yeah, 5,000. So look, I don't want to talk about the facts of the case, but is there something that went wrong here?
Yes, sir, there is. The paperwork is messed up or something happened because everything has been completed, all the fines have been paid, and I have actually a driver license for like 5 years now.
Oh, wow.
Everything has been done with the all the
So look.
schooling, all the schools, all the fines, everything, Your Honor.
So here's what we're going to do, Ms. Worthington. I believe you, okay? We just got to contact Monroe County, and if they say, yeah, this is something that should have been recalled, or yeah, he's taking care of everything, then they'll release you immediately. If not, what's going to be done is saying, well, okay, if it's not messed up, you're going to pick them up. And if they say no, you're probably going to ROR you here. That could take up to a week, though. So hopefully Monroe will get back to it right away about the case. All right?
Yes, Your Honor, there is a $5,000 bond on the case. Can I go ahead and bond out?
Yeah, I said 5,000. Yes, sir. There is a bond.
So I do have a bond, right, Your Honor?
You could bond out right now.
Yes, sir, I'll do that.
Yeah, they show it as no bond, but I show it as a 5,000.
Yes, sir, I would like to bond out, right?
Okay. Well, good luck.
Thank you, sir.
Oh, sorry. Okay, so now we're up to these. What? There. Yeah, it's there. Okay, so are we up to Mr. Doherty?
Yes, sir.
Okay. So here's what happened, Mr. Doherty. So Seminole wanted you, Judge Rexagler was contacted, and she said to adjust your bond to $500. And you're scheduled for a new court date before Judge Woodard, County Court, on June 9th at 9 a.m.
Well, Your Honor, the whole reason why, Your Honor, I missed the court, Your Honor, because I was incarcerated inside of Orange County Jail, Your Honor. So I was wondering.
Hey, it happens. I agree with you. The problem is you got to tell Judge Woodard about that, because I can't do anything with it unless they agree. And we've already contacted them, and they reduced the bond from $2,000 to $500.
I can't get R&R, sir, because I'm in the process of getting my income tax together so I can be able to get out.
Okay, hold on a second. Let me go through this. So they took no action on this Orange County cases. So jail,
Yes.
Madam Clerk, State PD, help me here.
Okay.
During this COVID-19 crisis we're facing, I thought we were contacting the out-of-county jurisdictions.
Yeah, that's what
And they came back and said 500, but
right. It was originally
it was 2,000.
right. So they contacted Judge Carter, contacted the other county.
I know, but it's still a monetary bond.
That's what the judge. What's his name?
Judge Rick Sadler. She said that. Yeah.
She said, yeah. I don't know.
So jail. Any pearls of wisdom?
Your Honor, I have the same information as you. Judge Carter's being in contact with the judge out at that county, and I have the exact same thing to give him a $500 bond with the next court date before Judge Woodard on June 9th at 9 o'clock.
Yeah,
that's
they got to
what I
come
have
pick
as
them
well.
up. They still got to come pick him up if he doesn't post the bond. So why wouldn't he be reset then for one more opportunity for them to pick him up? And if they don't, ROR them.
Okay, Your Honor, I'm looking at the last teletype that was sent. If you can give me one moment. Let's see.
Okay, well, here's what I'm gonna do. Yeah, we'll reduce it as Judge Rex Sadler okayed, and we'll reduce it to 500. But I'm going to require that he be reset before the weekday IA judges to determine whether he should be released on his own recognizance.
Okay, because the last teletype, Your Honor, was sent on April 22nd at 5:23 regarding the pickup acknowledgement. That's what I have. And that was as of April 22nd.
Reset this for Monday or Tuesday.
Okay.
For Judge Carter or Judge Wisted to deal with it because it's still monetary.
Okay.
Okay, so we'll see what happens, sir, all right?
Yes, sir.
Okay. I got Mr. Epperhart.
Yes, sir.
All right, also Seminole County. Let me see what yours. Must be picked up within 24 hours or subject to release.
This is the app.
The Epperhart.
Right here.
Okay, hold on. Sorry. All right, so we contacted Seminole and Judge Rex Saylor said to keep you on a no bond status. So we need to make sure he gets reset for IAs for them to look at it.
I mean, when he first came for the IA hearing, he came in first. And Judge Carter contacted the other judges down there, the state attorneys, and that's why this time to bring them back. We don't bring them back a third time, but if you want them to reset it, I don't know if Judge Carter gonna have them come back a third time. They only do it just twice, and that's why they contact the other time, and we get that printout there from the judges, and the state attorney and the from that county, saying what they want.
I don't know what Judge Carter told Judge Rex Saylor.
Right.
Fish or cut bait, I don't know what she said.
We get that from the JA, from her JA. That's why, I mean, but if you want me to reset,
I want to reset because I don't want to release some ROR if there's something else going on there.
I don't know what his charges or why she wanted people in to see her. You know, I don't know.
All right, so we're gonna have to reset you to let the judge because you're still in a no bond status. All right, Michelle Mouladon. How are you doing?
I'm okay. How are you?
Good. All right, so we got a Lake County warrant. And so they have agreed to release you on your own recognizance on your Lake County case.
Thank you.
But you got to make sure that you got to appear
Right.
in Lake County on your charges. Do you understand?
Yes, sir.
Trying to find out when your next court dates are. You'll need to check with your attorney and find out, but make sure that you show up or they're going to
Okay.
issue another warrant. Okay?
Thank you.
All right. Who else we got? Do we still have the Vietnamese, correct?
Yes.
Is that who's next?
No, Your Honor. David Pauly.
Okay, I'm sorry. Hey, Mr. Pauly, good afternoon. How are you?
I'm here.
All right. So it's alleged you committed the offense of soliciting without a permit. And this is a pleable, correct, Jail?
Correct, Your Honor.
All right. Anything I need to know about his history before I give him an offer? See if he wants to do it?
Your Honor, he does have 2 failure to appears. The last one was back in 2017. He has 5 felonies, 2 misdemeanors. His last conviction was back in February of 2024, resisting in a trespass. And he has no out-of-state history. His father convictions consist of trespassing, petty theft, battery, city ordinance, and a resisting.
All right, is he on probation for
No,
anything?
no, Your Honor, he is not.
All right, sir. So, State, do you want me to do the offer?
Yes, Your Honor.
Okay, so based on what I heard, Mr. Polly, if you want to plead to this listing without a permit, you'd be adjudicated guilty and sentenced to time served plus court costs and no return to the scene. You want to do that, or do you want to go out on bond on your $250 bond?
No, I'll do that.
All right, so they're going to give you some paperwork to fill out.
We don't have paperwork for him to fill out, Your Honor.
Oh,
It's
yeah.
an oral plea.
It's an oral plea. Your Honor?
I'm listening.
Oh, okay. I was told we don't have any paperwork for him to sign. It would be an oral plea.
So there's no paperwork for waiver of rights or anything there?
They do it oral.
They do it oral, Your Honor.
Okay, let's swear him in.
Raise your right hand.
Raise your right hand.
Swear affirm the testimony shall give you the truth, the whole truth, and nothing but the truth.
Yes.
Please state your full name and date of birth.
David Lee Pauly, March 6, 1990.
All right, sir, you're charged with the county ordinances listing without a permit. The offer is an adjudication of guilt, time served, court cost, and no return to the scene. Do you understand?
Yes.
All right, and are you currently under the influence of any pills, drugs, or alcoholic beverages?
No.
Suffering from any type of mental illness or emotional disturbance?
No.
How far did you get in school?
College.
All right. Have you entered a plea form before on your other cases?
Yes.
All right, would have been the same plea form. Do you understand the rights that you're waiving by entering a plea to this case?
Yes.
So there'll be no trial.
No.
So you won't be able to cross-examine state witnesses. You won't be able to call witnesses. You're giving up your right to remain silent, and you're giving up your rights to appeal, except as to the legality of the sentence and the jurisdiction of the court. Do you understand that?
Yes.
All right. Are you entering this plea freely and voluntarily?
Yes.
Is anybody forced, threatened, or coerced you to enter this plea?
No.
Okay. So then, as to the, are you a U.S. citizen?
Yes.
All right. And you're not previously been convicted of any type of sexually violent predator or anything of that nature, are you?
No.
Okay. All right. So, as to the charge of soliciting without a permit, how do you plead? No contest, guilty, or not guilty? I'm sorry.
No contest.
All right. I'll accept your plea of no contest. I'll find that you're alert and intelligent. You understood the nature of the charge, that it was freely and voluntarily entered, and that there's a factual basis. I'm going to sentence you to adjudication of guilt, time served, court costs, which are, no, did not appoint PD. 223, report to the clerk's office within 90 days to work out a payment schedule. And yeah, so we got all that. Okay, so remember, you got 30 days to appeal my decision. Notice appeal must be in writing. If you can't afford an attorney, one will be appointed so you qualify.
Yeah.
All right, sir? Okay. So, Vietnamese?
Yes.
All right, we're going to get on the language line. Give us a minute or two.
Okay.
Where? Like audio controls? Teleconference? Okay, this is Judge Jordan. Who's on the line with us? I'm sorry, go ahead, do.
838.
All right, you're going to have to spell your name for us. We appreciate you helping us out today. Can you spell it?
So E-O-N-G.
How do you spell your last name? Or was that it?
D-O.
Okay. All right, so you're a qualified Vietnamese translator?
I'm not translating court case, but I can try.
Oh, I appreciate that, but it's like landing a plane. You know, we want someone that can do it, not who wants to try. So what we'll do, well, listen, I've got you on the line. So we'll do this. If you can start translating, let's see what happens. All right?
Yes, sir.
Okay, I'm going to start talking to the defendant. All right. Are you Miss Ona, O-A-N-H, Go, N-G-O?
Bà có phải là An Ngô không?
Yeah.
All right. Do you speak a little English?
Bà nói được tí tiếng Anh không?
Cũng được.
Yes.
Okay, you're here because a judge issued a warrant.
She has the immigration. That's all we have to just advise her that she.
Oh, I'm sorry. Stop. You're here because there's an immigration hold on your case.
Bà bị chịu tới đây bởi vì hồ sơ di trú của bà bị tạm ngưng.
So you won't be able to bond out until it runs its course. We didn't hear that.
Hồ sơ nó sẽ không được.
Can you repeat that? There was some interference.
Cho nên hồ sơ sẽ không được tiếp tục xử lý cho đến khi nào cái phiên tòa này được giải quyết xong.
Do you understand?
Yeah.
Okay.
Your
Anything else, Jill?
Yeah, Sharona, yeah, with Miss Nidro, that bond was already paid, so I don't know if the bondsman is going to wait to get the status of the immigration hold to see if they're going to come off that bond. So
Gotcha.
hopefully we'll have something by today.
Okay.
You want us to IA her? Or no?
So we're just advising her about the ICE hold.
Yes, correct.
Okay, I think we've done that.
Yes.
So thank you, Mr. Hogue, on the phone. We're going to let you go. Did you need our case number?
No, sir. Thank you.
Okay. Have a great day.
Thanks. Bye.
All right. Jail, anybody else we can help?
No, Your Honor, we're done, honey. Come on now.
Well, I'm not going anywhere. Is that a no?
Correct, Your Honor. We're completed.
All right.
Thank you, Judge. See you tomorrow.
Okay, don't forget to bring bagels tomorrow.
Oh, okay. I won't be there.
All right, y'all have a good day. We'll see you tomorrow.
All right, you too.